Yo, yeah, we in court. We in court. We in court right now today. We gonna really talk about it. We gonna really talk about it, buddy.
Bluetooth connected.
Yeah, what's good with y'all? We got this court session going on this morning. We in that court. I told y'all we was gonna be in court. What's good with Adewale? I'm muted right now. What's good with y'all? We working with the courts right now. I put them on the Raptor. I put them on the loudspeaker, so they might be talking through that loudspeaker on the Zoom. I need to plug my phone up so I can charge. Yeah, we ready to rock. Yeah, bro, I've got to say, though, in a very respectful way, I think you're kind of crazy, though, taking on the powerful entities, the state of Cali. Hey, bro, no, you're crazy. Hey, listen, if you scared, my nigga, go be a slave, my nigga. You tripping. There ain't no powerful entity, nigga. This ain't the state of California, my nigga. This is. See, you don't know God out of Wale. That's why you scared. That's why y'all niggas be scared. Y'all be scared because y'all don't know no laws. Y'all don't know those constitutional rights. You don't know it. You have no idea. Taking on a powerful entity. Nigga, what? Bro, you tripping. This is the powerful entity, bro. Amen. That's the supreme being is the powerful entity, bro. All other things are made or just tests for you to become the powerful entity. I could care less what these people talking about. East Oakland Boxing Association. That's what we do. And this is what I'm saying. I'm looking at this constitution. And it says, no, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. They're trying to seize my home and my person's home. Troy DeMond King Trust is my person. And it's foreign and private. That's just the respect. And then the Fifth Amendment, no person shall be held for capital, otherwise infamous crime, unless a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in militia, when the actual service at time of war or public danger, nor shall a person be subjected for the same offense but twice put in jeopardy life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's the Fifth Amendment. They're taking my property and trying to kick me out of my home without just cause. You can't do that. You can't do it. This is the Troy DeMond King's trust. He's using this for banking. And I'm not Troy DeMond King. This is when they're going to have to be understanding that. And I'm going to be talking to him just like that. So what do I need to do? Because I'm not Troy DeMond King. That's what I'm saying. Them Fourth and Fifth Amendments, bro. Them ain't to be, you can't be, you doing too much. And they locked up my mailbox. I can't even get my mail. Like, that's against the law. That's mail fraud. I'm protected by the 11th Amendment. Also, the judicial power of the United States shall not be construed to extent to any suit in law or equity commenced or prosecuted against one of the United States citizens by citizens of another state or by citizens or subject of any foreign state. I'm a foreign. I'm an American national. Filed at college. Listen, I got the paperwork right here. That's what I'm saying. Niggas is about to be hurt. And when if they wanna argue about it, they can argue about it. They can argue with themselves. Hold on, look like somebody in there talking.
Bluetooth disconnected. Bluetooth pairing.
Hold on, I'm gonna see if my earphones, cause I can't hear. I don't know what that sound ain't on. I can't hear nothing. I don't even know if they talking yet though. The judge might not even be in there though. Oh yeah, I ain't started yet. It ain't started yet. There we go. I got it on speaker now. So I'll be able to hear. It's not breaking news. We already talked about that. We already talked about it. Let me see who on the docket. Okay, yeah, 9 a.m. I am ninth. Let's look at the chart. What's good with Raw? We in court. Just waiting on these folks, the judge, to get in here real quick. Yeah, we in here just chilling, waiting for the judge and them to get in here. She ain't in here yet. Okay, I hear somebody. Yeah, go ahead and get them questions going on that live though. Yeah, we already talked about Ryan's B sample coming back having more ostarine in it than the first sample. What's the name of the store? What are you asking? Yeah, we in here waiting for these people to get in for these courts. They be taking all day. See, this is why when you know them amendments, it's bad because the 11th Amendment says the judicial power of the United States. And that's the judicial power of the United States we're in. You see what I'm saying? Okay. Somebody's mic having feedback. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens or another state or by citizens or subjects of any foreign state. And the United States is this judicial branch. of the United States in California, Alameda County, they trying to be on my ass and they not supposed to. The judicial power of the United States shall not be construed in extent to extend any suit. If you a citizen, you can't extend no suit to me. Your store with the herbs. The Amazon link, hold on, it's right here. You go to Amazon link right here. Amazon storefront with the herbs. There you go. It's in the chat. Yeah, Mel, that's the Amazon storefront right there. Get your herbs off of there. And then I get commissions. Hey, listen, we with the East Oakland Boxing Association too. Program director of the East Oakland Boxing Association. We got an executive administrator. I'm basically the program director, East Oakland Boxing, the town. Hey, listen, once again, he said the B sample was going to come back positive. Remember, the first sample had a billionth of a dosage, and it had no performance enhancing. Definitely pause. The first sample had a billionth of a dosage, and it had no performance enhancing effects. That's what I said. We gotta go on. We gotta get these niggas on YouTube. Cap with this cap shit that they on. These courts in this cap. Hey, listen, y'all want the link to the Zoom? Hold on. Y'all want the link to the Zoom? Y'all can hop up in there. Oh, I'm already in there. Copy. My mom literally calling me. Nobody's even in there yet.
Good morning, everyone.
She in there.
We have a number of law in motion and ex parte matters that we will be hearing today before we move into our court trials. And
That's the Zoom link if y'all want to get in that court trial.
We do, and I will say this again because our court trials are scheduled for 9:30, but we do have a mediator available today, Judge Herbert, who is a retired judge with the Alameda County Courts. If there are, good morning, Judge Herbert, if there are parties here already that do have a court trial scheduled and may be interested in mediation, I would like to send you off to work with Judge Herbert now because this will be a long morning, and I think it's very unlikely that we get to all the court trials.
I would like to mediate with Judge Herbert. Today.
So is there anybody here right now for a court trial as opposed to law in motion? Okay. Let me... Right, and I know for your court trial is your attorney is not here today.
This is the judge.
Right. Okay. So we will need to deal with that, and we'll deal with that after we get through law in motion. I saw a hand, ma'am. Which case are you on? Oh. So this is on a law in motion matter, not a court trial. Is anybody here for a court trial right now? Mr. Danielle, which case? It's law in 23.
I'm about to ask him.
Okay. Do we have Mohammed Wahidi here? No, so that one. He did not show up yesterday. Mohammed Wahidi. No, and ma'am? Thank you. I'm just trying to see if there's anybody I can send out to mediation quickly. Do we have Nathan Ross or Jennifer Hodgson here? Excuse me, behind you? Are you? Okay, thank you. All right. So Judge Herbert, we don't have anybody here right now, but more folks will likely show up soon. Thank you. All right, Madam Court Reporter, we ready? Thank you. All right, on line 1, Lynn versus Keys. Yep, please come up. Mr. Horowitz, I can see that you're online. Please unmute yourself and turn on your video.
See, that's the lawyer.
This is your matter.
That's the lawyer I got. I gotta
Lynn
go
versus
again.
Keys. And I do suspect you may not have received notice on this one. If we can please, Ms. Keys, if you can state your name for the record. Sure. And if we can swear Ms. Keys in. Ms. Keys, did you review the court's tentative ruling yesterday? So the court's tentative ruling was to deny your motion to set aside and vacate the judgment because it does not appear that it was properly served or properly noticed. You need 16 court days before the hearing, and we can print out a copy of the tentative ruling for you.
See, people don't even know.
And so the motion did not include the proof of service on Mr. Horowitz.
People don't even know how to file a lot of this paperwork.
That would make sense why I haven't received it.
And then they be denying people their right to do anything.
In this case, I know she's requested a couple of stays, which we had not known about either. I just want to make sure the court also knows that we do oppose any further stays of execution on this matter.
See, they don't even want them to have any requests to stay.
You may.
Okay, so when I submitted both of the stay of execution,
That's what I requested.
And I had attached the proof. When I came in last, I think it was Tuesday, and it was denied. That was the
Yeah, see, I don't have to do, this is what I'm about to be, like, I don't even have to do a request to stay. Like, why am I requesting to stay under duress?
So, Ms. Keys, thank you. And I can see the most recent request for stay was denied because it was outside the time period. So, the tentative is affirmed.
See, they just gonna bag them.
Thank you, Ms. Keys.
She don't even know what's going on.
So with this motion, I actually filed this on Tuesday, and I certified a copy to Amy Lynn yesterday.
Okay, so Ms. Keys, that's not 16 court days.
Okay, so.
And also, she's represented by counsel, so it should be sent to me.
Okay. So, Ms. Keys, you can speak with self-help if you would like, downstairs, or if you have counsel, certainly speak with counsel. We also have a packet of resources that are available, but the tentative in this case is affirmed. Thank you.
See, they don't care.
Line 2, Guiton versus Parks.
Good morning, Your Honor. Waldo Fernandez for Defendant Parks.
Thank you.
anything, Your Honor.
Thank you. And Ms. Guiton?
Yes.
Thank you. Once everybody is seated, I'm going to ask that the parties state their name for the record, and then we will swear in. Okay, swear. All right. Let's swear them in first, and then they can state their name.
This is why I be on. Y'all can get up in that courtroom if y'all want to. The link right there on the Zoom. If you want to get up in there, pause.
Jesse Keaton. Leah Parks.
There you go, right
Thank
there.
you. So,
Pen.
Mr. Fernandez, I did certainly review defendant's motion to set aside the default judgment. Ms. Guiton, is there anything that you would like the court to consider? Is there any evidence you would like to present?
Well,
And please speak into the microphone.
I would for the court to consider the fact that Ms. Parks has been paid rent since October of last year. In the last 4 years, she has only paid rent maybe 6 times.
All of these is over evictions.
I'm sorry, Ms. Parks, I'm going to ask that you not shake your head while Ms. Guiton is presenting testimony.
In her,
She keep telling her not to shake her head.
she said that she was not served properly.
What the fuck does that
She
mean?
said that
I'm asking you not to shake your head while she's testifying.
a
Like
right
what?
to post, and the court did approve my ability to post on the 27th of February. She was served on the 28th of February. She said, excuse me. She said she did not know how to get help to help herself after she was served, and I have proof that she did know how to get help. I have copies.
I'm about to be asking mad questions.
She said she did not know about the eviction. I have proof here that I did let her know about the eviction. I cannot afford to have her continue to live there. I have exhausted all of my resources in the past 4 years. I understand COVID. And so I have had to use my resources to keep a place for her to stay. I cannot afford it anymore.
She said she can't afford to let somebody stay in her crib.
I believe I have a right to the $7,200 that she owed me at the time of the filing.
Just over
Ms. Guiton, Mr.
7,200.
Fernandez?
Well, Your Honor, I reviewed the court's tentative ruling requesting that Ms. Guiton bring a process server to testify or declaration by a process server, and I did not hear that from Ms. Guiton. But I'd also like to highlight for the court what I think are 3 strong grounds for setting aside the judgment based on a void judgment that include that the case of the unlawful detainer was prematurely filed. It was filed on 1 day's notice. Plaintiff's papers, the complaint at paragraph 10, say that the notice was posted on December 30th, and the complaint was filed on January 2nd. That's 1 day's notice maximum. The earliest possible day that this complaint could have been filed would be January 4th. So this court never had jurisdiction, subject matter jurisdiction, to enter judgment in this case, default or otherwise, independent of the method of service. I reviewed the second ground for a void judgment is that that there was no posting order in this case. Plaintiff applied for a posting order and was denied one on January 29th and submitted a second application on February 1st, but I was unable to find a ruling on that second posting order.
So I will note, Mr. Fernandez, there was a posting order that was granted.
I apologize.
is in the register of actions. For some reason, the document is not coming up. The ruling is there.
I think that was my confusion. Thank you, Your Honor. I think the first ground for void judgment is sufficient for setting aside the judgment because there was no subject matter jurisdiction for any kind of judgment based on lack of service of a proper notice and lack of proper 3 days notice pursuant to 1161 sub 2. The notice is also defective because it does not include the rent board's email address, which is
See, this is just, they just be talking about
separate
anything.
from that, going into the lack of actual notice by defendant, it's well documented in her declaration that she first became aware of the lawsuit on March 17th.
Not even talking about nothing.
Judgment had already
They're arguing over filings.
She first saw the papers in this lawsuit.
They're arguing over who filed what. You just heard in the papers.
Makes sense given that the lawsuit was filed with the incorrect address for Ms. Parks.
They arguing nothing, my nigga, and they talking about somebody's living arrangements. They're not even talking about nothing.
Which is the address that Ms. Kitan used on a previous unlawful detainer matter in 2019. This time around, she's excluded that upper unit designation.
They're arguing over. She's not even, bro. This shit be so much corporate jargon.
So I don't know where this summons and complaint was allegedly posted, where at the building, at the structure it was allegedly posted. We don't have a process server here to testify to that. And it's believable that Ms. Parks never received notice on February 28th, which is the date they say.
I could say I was never served anything. Troy DeMond King Trust is, I'm not Troy.
Ms. Kitan, do you have anything else that you would like to add? Do you have anything else you would like to add? Do you have Mr. Alt here to testify?
This should just be corporate talking about, I mean, I'll file this and
Right. And the court does have the proof of service. However, the plaintiff does bear the burden to show that the defendant was served and had notice. And without Mr. Alt here, I don't see how the plaintiff cannot meet her burden in this case. So the motion to set aside and vacate the default judgment is granted. The writ of possession is recalled and quashed. And I believe we have a proposed answer was submitted. Is that correct, Mr. Fernandez?
she's gonna be trying to talk that corporate jargon. I'm gonna say, can you please
So you will need to
explain
file
that for my
answer
audience,
by
my
the
witnesses?
close of business on May 28th.
Your Honor, may I ask that the court reach the question of void judgment for filing the complaint before the notice had expired? Because I think this would allow the court to dismiss the case and save judicial resources. I don't think it's in anyone's interest for us to litigate this case further if it can be disposed of now.
I do understand that, Mr. Fernandez. Ms. Kitan, are you prepared to discuss the issue of the void judgment, the supposed void judgment with the notice to quit being served on December 30th, but the complaint filed before that time period expired?
What? They arguing over when something was filed.
Yes.
Like, this is why you can't, this shit is a joke. You seeing, you hearing it.
Ms. Kitan, the notice to quit, 3-day notice to pay or quit was served on the 30th. And you
A
filed
pay or quit.
on January 2nd, which does not exclude weekends and judicial holidays. So that you filed it prematurely.
They're arguing because they gave her a pay to quit, but she filed the paperwork prematurely.
That does not mean that you cannot refile with a new notice, but it must comply with the City of Oakland's just cause for eviction ordinance. It's implementing regulations as well. Thank you, everyone. So this case is dismissed.
Thank you very much, Your Honor.
Line 3, Harris versus Saba.
They was arguing over premature filings.
Good morning, Your Honor. Sobe Matthews, specially appearing for Sean O'Neill, attorney for plaintiff Harris.
And you are, sir? Lee Harris. Okay, Mr. Harris, you can sit down. Do we have Julian Saba? Let's see. We can swear Mr. Harrison, please. Okay, Mr. Matthews?
Yes, Your Honor. I don't think we're contesting the result of the hearing or the motion. I think we are arguing that the court may be misinterpreting what happened with regards to the service. According to
They arguing over if he got served correctly.
it was done by Mr. Harris.
Did you get the fucking paperwork, bro? Come on, man. This shit crazy. It's all good though. I ain't tripping because I want to see what he got to argue about my paperwork.
Basically, Mr. Harris got an application to post approved, and he submitted 2 proofs of service, one for mailing and one for lack of a better word, mailing.
You see what I'm saying? They talking a proof of service is a form you fill out.
I believe the first one was for when he posted it, and the second proof of service was for when he mailed it. So there's no defect with regards to the application to post, and so there's no defect with regards to.
We already talked. We already knew that it had the dosage was so small, it had no performing enhancing effects. We already talked about that.
What is your name? My name is Julian. I cannot hear. There's an echo on your end. Okay, can you hear me now? Is there another device that is on in your house?
Okay. No. We just turn off. Sorry about that.
Okay, that's better.
Can I have a translator?
Wait, you need a translator?
Yes, please, the Spanish speaker.
Yeah. There was no request for Spanish Spanish.
But it's okay.
But okay.
Lady don't even speak English.
Approximately how long do you think it would take to get to the vehicle? Then I know we'll need you. Okay. And I'm just thinking because it appears that Mr. Matthews is not actually contesting the tentative, that kind of the underlying outcome of the tentative, whether.
Yeah, I'm not, Your Honor. I'm only seeking clarification as to when an answer should be due because she was properly served pursuant to the application to post. So that's all.
Thank you. Okay. All right. Ms. Saba, we're going to swear you in right now.
Yeah, okay.
All right. No, we need a translator. So, yeah. You can do it from the table?
Yeah.
Okay.
Sí, señora, va a ser juramentada. Raise your right hand. Levante la mano derecha.
Hola,
Do you solemnly state under total authority Jura ser bajo pena de perjurio. That the testimony shall share. El testimonio que va a dar en la causa. Shall be the truth, the whole truth, and nothing but the truth. Será la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes. Por favor, diga su nombre para las actas.
Mi nombre es Julián Savage.
Juliana Savage.
Yes.
Being
You
assistant
talk Espanoli.
interpreter. Sophia Oñate, certification number 301597 with oath on file.
Thank you.
Gracias.
Gracias.
Okay. Mr. Matthews, I believe the answer was due by the 8th of April. Sorry.
Parece, señor Matthews, que la respuesta se tenía que haber entregado a no más tardar el 8 de abril.
And there's a demur on file on the 5th, or a response was due on the 8th.
La respuesta se tuvo que entregar el 8 y tardaron en deber el 5.
If that clarifies things.
Si es que eso le ayuda a aclarar las cosas.
Are we talking about the current motion right now?
Estamos hablando de la petición actual.
The current motion is to set aside the default and default judgment that was entered on the 4th.
Yes. And if you look,
La petición actual es para suspender el fallo que se hizo por falta de participación el 4.
Listen, when they ask me how I get back in my apartment, I'm gonna say Troy let me in.
Wash, Your Honor, was March 7th.
See,
Right.
Troy let me in my apartment,
If you
and,
look
and I
at,
realized
her
nobody has fed
answer, or
Troy's
sorry, her
animal.
declaration on
So I'm trying to figure out what's
the
going
motion
on.
to quash
Because
at the
when they
bottom of
changed the
page 4,
locks,
she
the
references
sheriff
that she is
said
just
someone would
filing
feed
this
Troy's
in
animal.
order to,
I
as
sat
a
outside all
precaution,
day. No one came and
because
fed
she's not
Troy's
even sure
animal. I
if she
sat
got served.
outside
If you
Troy's
look at our
door
diligence
that
statement
whole
in our
day, and
posting
nobody came to
application,
feed the
Well, you
animal.
need to pause, Mr.
They even
Matthews,
put my
because we
animal
have
in danger.
an interpreter.
Okay, la petición para suspender se tardó el 7 de marzo y si ve usted la declaración
On
que
top
dio
of
la
this,
señora para esa
I know you,
petición
I know you guys don't care, but you put my animal in danger. They've locked me out of my property, and no one has done anything. And they locked me out of my
If you
mailbox.
look at our posting application to post, we submitted 2 applications to post with the same declaration of diligence. We made over 10 attempts and we staked her out even twice to try to get her served. So we never actually even claimed that we had served her before we did the application to post. So the court didn't even have, she didn't even have a basis to file that motion to quash because we hadn't even filed any actual document of proof of service or even attempted anything. That's why we sought the application to post.
And that is why we dropped the motion to quash.
Understood. So is the application to post still, so the service we
Oh,
made?
sorry, wait, Mr. Matthews, sorry.
Sorry.
Ok, habíamos hecho para poder entrar para verificar y hacer oficialmente la declaración.
So this is what they be doing all day. They be just talking about nothing. A motion to quash mean to dismiss it, to be done with it. A motion to quash means to be done with it. We don't do scared business, my G, on here. I'm the real Lennox for God. I'm serving God right now. And I'm putting you guys on with public information on a public platform. It's up to you if you want to actually listen and adhere to it.
Your Honor, is confirmation that the subsequent posting and mailing proof of service we submitted are still valid. And we just want to know is if we need to reserve her or if she will be filing an answer pursuant to the fact that we are setting aside the default.
Si necesitamos de nuevo hacer la entrega de documentos oficialmente o si ella va a entablar una respuesta que estamos pidiendo que se haga fallo o falta de participación.
The order to post defendant filed a responsive paperwork, or a demur, which is scheduled to be heard on the 30th.
La petición para publicar aún sigue gratuita y la petición para suspender está tardado para el 30, perdón, está agendada para el 30.
Okay, Your Honor, I was looking at the docket yesterday. That wasn't on the docket. Is that the new demur?
Estaba viendo esto, señoría, y eso no lo vi.
The demur was filed on April 5th.
The mirror is an objection to a complaint.
Opposition was filed on April 23rd. And
You know, these are some of the things I'm sacrificing because I'm ninth.
To May 30th.
I'm sacrificing on behalf of the squad so we can learn, because this is what Ryan be going through. False accusations. False accusations.
Exactly.
Thank you, Your Honor. I apologize for the confusion.
The tentative is affirmed. Thank you very much.
Told you, Navy Federal. See, that's that bond. I had to bond out $25,000 without a bank account.
Portola Livermore versus Hutchins.
Anthony Penley appearing for the plaintiff.
Look, this was last year. What is the date on there?
Mr. Harris, the tentative was affirmed. So
5/26/2023. We almost on a year to the date when they put out them straps on me at Navy Federal, and they still haven't done anything.
It was continued to the 30th is what happened the last time you were here, and your attorney was speaking for you. So if you want to have a conversation with your attorney, you can. May 30th.
He don't even know what's going on because his attorney was speaking for him. It's just I'm sacrificing my time about boxing and nonsense. I know, I got to worry about my business. My business is at the court. They listen, watch. When they swear me in, they're gonna be like, "Can you explain to the court why?" Because Troy DeMond King Trust is a foreign private entity. It's a trust fund filed at California Secretary of State.
Thank you. Ms. Hutchins, did you have the opportunity to review the court's tentative ruling?
Hold on, I gotta give this nigga Leo some more water.
So I fixed to get a settlement from workers' compensation, and I've been.
Is someone explaining that they're getting workers' comp and they're trying to make sure that their business is handled?
But I don't feel that I should be responsible for the whole bill because she just doesn't let it be shown. She signed an agreement with the property management just like I did.
Somebody being held for capital and somebody else ain't. This is a learning tool. This channel is for learning. Like, I get it. Y'all want to talk about niggas cheating and all.
But I will note, Ms. Houchins, that the overruling of the demur just means the case continues. It doesn't mean that, the plaintiff, judgment for plaintiff. It just means that this matter continues.
That's okay. That just gives me a little more time to find a place to go or to figure out if I could work with the plaintiff on downsizing from a two-bed to a one-bedroom and paying my bill when I get my settlement money or SSI, which I'm getting a letter from them June 10th. So even if the case continues, at least I'll only owe half of the amount, and possibly I'll either be able to start paying or I'll have a place to go to. The lease actually expires next month. So
This is sad because these people don't be having
I'm okay with
nowhere to stay.
not okay with
Hey, listen, if y'all want to get in on the thing and watch in the courtroom on the Zoom, it's in the chat.
Mr. Fenlilio, is there anything that you would like the court to consider?
No, Your Honor. I think you've really covered everything. I just want to reiterate, Ms. Houchins can contact me. We've actually opened lines of dialogue. So if she wants to further provide continuing communications and about her situation, I'll be happy to share that with my client.
Thank you, Ms. Hutchins. So the tentative is affirmed. Thank you. Before we move on to line number 5, Judge Herbert, are you there?
I am.
Okay. I do see a contested matter with both parties here. So, Mr. Bornstein and Mr. Curry. Given our court trial schedule, I think it would make sense to have the two of you work with Judge Herbert today, or this morning at least, to see if there's a way that you will be able to reach some sort of mediated agreement. I'm going to set you up in the witness room and the jury room to speak with Judge Herbert. Mr. Bornstein, do you have a computer? Okay, so you can log on. I'll put you in the witness room. Okay, and if we can set Mr. Curry up into the jury room. Yeah. All right, so Judge Herbert, this is line 18, Tessima versus Curry.
Thank you.
Yes, Mr. Curry. It is going to be a Zoom conference from 2 different rooms. I will let your assistant in this time. Yes.
You'll email me.
Yes, if we will email you the link. Thank you.
Your Honor, if you could ask your clerk to send me the co-hosting authorization, that would be helpful.
Absolutely.
Yeah, I want to talk to Judge Herbert.
We can make Judge Herbert a co-host. Thank you.
I want to talk to Judge Herbert.
And Mr. Curry, you will be going to the jury room, which is through this door over here. Okay, moving along
YSL RICO case.
Creekside Housing Partners versus Morgan.
No, this is just me against Alameda County. They don't be showing no civility in the courtroom.
Good morning, Mr. Mayberry.
And Laura Bixby for the defendant.
Laura Bixby.
Okay, Mr. Mayberry?
Yes,
Whenever you're ready.
thank you. I'm gonna apologize too if I'm reading slightly more than I normally do. I just want to make sure I get all these points across. So
And on the record, so let's do it slowly, please.
I'll do my best on that.
Thank you.
Your Honor, the first main argument that I'd like to make is the fact that the Washington court didn't follow all the rules of statutory construction when they came to their ruling. The plain meaning of the statute is that the tenants must be given 30 days to vacate. That's where it ends. Arguably, if this law completely supersedes state law, then there really is no cure period under the CARES Act. In fact, it just says, okay, we've just got to give 30 days at that point. The only way you reach any sort of cure period is by going outside of that and into the state law that just happens to mirror Washington and California. Not all states mirror those two laws. The Washington's decisions actually attempt to intermingle the federal law with their own state law. That was the only reason they came to that, is because they went into an in-depth discussion about what Washington law was, not what the CARES Act said, but what their actual state law said and required, as opposed to the actual wording in the CARES Act, or staying within the confines
Slow it down.
of that specific legislation. It failed to give any deference to the plain meaning of this requirement, and instead chose to find that the simple 7-word phrase, tenants must be given 30 days to vacate, is somehow ambiguous. I'd say furthermore, the Washington cases go outside the statutory scheme of the CARES Act to determine.
See, this is why you go in court, because now the CARES Act say I get 30 days to vacate. So I need my 30 days. But I want to talk to Judge Herbert about my psychological, how this has damaged me.
Let alone required for a non-payment notice, other than to go outside the CARES Act and commingle with state law in the state of Washington, much like in the state of California. It ignores the common persons doctrine, something they didn't even discuss in those decisions, which basically requires that a person of ordinary intelligence must be able to reasonably determine what acts are required. And that's the Grained versus City of Rockford case. That's 408 U.S. 104. Here it would be virtually impossible for a common person to determine from the phrase, tenants must be given 30 days notice to vacate, that somehow they must also be given some 30-day notice requirement in order to pay or to cure the violation. It also ignores the vagueness doctrine, which states that laws are void if they are vague when they fail to give reasonable notice to the reader of all the behaviors that are prohibited and compel readers to make presumptions or to guess at their meaning. Again, we have that same issue. A vague law impermissibly delegates basic policy matters to either policemen, judges, or juries for resolution on an ad hoc and subjective basis, with the attendant dangers of arbitrary and discriminatory application. That comes from the Papa Christou versus City of Jacksonville case. That's 405 U.S. 156. It also quotes from Klein versus Frank Dairy Co., which is 274 U.S. 445. And Connolly versus General Construction Company, which is 269 U.S. 385. And finally, Sewell SEWELL versus Georgia, which is 435 U.S. 92. The issue we have here currently is the fact that arbitrary application is already happening based on the tentative ruling as it stands right now. If the court adopts that ruling, the rules in Alameda County will be different from those that have been decided in Contra Costa County, in Santa Clara County, and Stanislaus County. The issue here is that we're talking about a federal statute as well. It might be fine if it was a local ordinance or something like that to say, okay, well, those rules are going to apply differently in Alameda County. But we're talking about a federal rule here that has to be applied, and frankly should be applied the same way across the board throughout the entire state and in every state, which I think creates a whole other set of issues because, again, the assumptions by the Washington court are that there is a cure period in every single state, which is not the case. In fact, in the state of Arkansas, you can actually refer to the district attorney's office.
He is on their ass.
And the idea here is that Congress had to put something in place that would work in all 50 states for everyone to interpret the exact same way.
Exactly. He's talking about Uniform Commercial Code.
Certain ramifications, and whether or not there was even a judicial process for eviction. There are still some states that go as far as to say, look, you have 3 days to give me that money or I'm taking the doors off the unit, as opposed to going through any sort of a judicial process. further argue, the winners for people of New York case, that's 333 US 507. It says, men of common intelligence cannot be required to guess at the meaning of an enactment. It is established that a law fails to.
No, you ain't gotta wish me the best, bro. I appreciate it. What's gonna happen is gonna happen, and I'm showing the people how they be breaking law. Dude is on their ass though.
Which is prohibited and what's not in a particular case.
And see, I've never see she letting him get his bars off. They won't let they be bitching when I be trying to get my bars off. But we gonna see today.
451. And then Baggett versus Bullitt. Baggett's BAGGETT versus Bullitt BULLITT. That's 377 US 360. Certainly, one of the basic principles of the due process clause has always been to protect people against having government impose burdens on them, except
Exactly.
land. The implicit in the safeguard is the premise that the law must be one that carries its understandable meaning with legal standards that courts then can enforce. The issue here, Your Honor, is that going outside the statute determined there's some sort of curable period. It's not there. You can't. I would challenge the court to ask many of the pro per landlords who come into this court and read that specific section and say, do you find a 30-day cure period in there as well? I think the answer would unanimously be no. And I think that these doctrines were either glossed over or specifically ignored in those Washington decisions because they didn't discuss them one bit. I think it also ignores what is the doctrine of original intent. Going back to the fundamental purpose of the CARES Act was, in this specific section, was to guarantee tenants sufficient time to obtain rental assistance funds necessary to prevent eviction. I don't think anyone can argue that these programs have all ceased at this point.
Yeah.
And frankly, in this county, probably more poignantly than any place else, you can't even evict people for what is considered COVID rent by either a federal standard, a state standard, or a local standard, because the local standard lasted for 37 months. We can't even bring the action for anything that's considered COVID debt by either the Board of Supervisors, or like I said, the state of California, or the federal government.
They arguing COVID debt.
I would also argue that, I'm sorry, I lost my focus here.
But I do want to ask you something, Mr. Mayberry. Yeah. So, you just stated that the purpose was to guarantee time to get rental assistance funds to avoid eviction. That time period to get the funds was 30 days, which would imply a 30-day period to pay as well.
Well, Your Honor, to that, I would argue that that implication is from judges, not under the common law, not under the common standard, which is a common person standard. It says very clearly in the cases that I've quoted that judges are not common people and that we shouldn't be using that as the standard. It may seem that way to us that are legally educated in some way, shape, or form, or perhaps,
he attacking him
from that specific eye and training. But the issue here is that it has to be something that can be determined by a common person, and that's not possible here. I would argue that up and down. It's impossible for somebody who reads, they have 30 days to vacate, that also means they have 30 days to cure the violation, especially when you have state law that says, oh, by the way, it's 3 days. And there's nothing in there that says they have 30 days to vacate, they also have 30 days to cure, or something that says
that's 60 days.
They intend to amend state law to basically get rid of any other requirements, and they now have 30 days to pay. There's nothing clear about that. And I think it's interesting to the fact that while all these cases have been going on, Congress hasn't done anything to basically go and say, no, that's...
See, this is the thing. He arguing what Congress be saying, and when I come in there with that shit, they be acting like...
That hasn't happened.
Well, Congress has done nothing.
Well, except, and I would argue, Your Honor, that currently there actually is a bill that is going through. Takes time, sadly. Wish it was done already. But, currently in the House and committee that would basically do away with this and would also clarify the fact that not only was the 30-day notice only supposed to last for the 30 days after the 120 days. Now, has it been passed yet? Because that's the only bill that we've had so far that's even been proposed in order to deal with this specific issue. So I think it's worth noting, since we're going well outside any sort of, quotable precedent in this specific action, we're going to other states, we're going to congressional intent, perhaps other documents. I know certain congressional research tools and things like that have tried to be introduced into that nature. But I think if you take the totality of everything into account and the fact that there is that bill still pending, I think it gives an interesting argument, on both sides, and that should be given equal weight for ours as well as the others from the state of Washington. But yeah. Can I continue on? You may. Thank you. And I would further argue that, again, relying on those Washington cases when they're interpreting Washington's law, not California's, I think leads to a faulty premise. And that's the termination.
See, he arguing district law.
That's the date the deadline to cure expires.
He arguing district law.
Ruling is actually,
He arguing California law to Congress law.
The termination of the tenancy must occur on the date the deadline to cure expires. And this is simply not the case under California law. These two dates coincide when using the most common notice used to evict a non-paying tenant, the 3-day notice to pay rent or quit. But Section 1161(2) does not state that the tenancy is terminated on the date the deadline to cure expires. It states it expires when the tenant remains in possession without the permission of the landlord after the deadline to cure. Thus, the state requires two parts. The deadline to cure must pass, and the tenant must remain in possession without the permission of the landlord.
Yeah.
Permission to remain in possession.
You hear what he said? The tenant must remain in possession without the permission of the landlord.
The tenancy is not terminated at the end of the cure period. It's actually terminated at the end of the 30 days. There's nothing in 1161(2) preventing the landlord from using a notice requiring the tenant to pay within 3 days or vacate within 10, or perhaps vacate within 60. In fact, evicting non-paying tenants from mobile home parks actually requires a 3/60-day notice. And the intent of that is to say, you need more time, obviously, in order to remove a mobile home. But that didn't equate to a 60/60-day notice, and that somehow the termination on that notice was after the 3 days to cure. That law has been challenged several times on several different levels and found to be constitutional and correct. It can be applied in mobile homes.
See, now niggas arguing. I see this. And that's why I said today I'm going to be in there telling like, listen, I'm an American national. I'm Hamza. Troy DeMond King Trust is my person. And I need to be secure in that till I can get the money to pay the rent. It's not saying I didn't want to pay it. I'm actually owed money. That's why I put a lien on the property.
But if the tenant were in fact able to actually get rental assistance funds after the 3 days, they could petition the court at any point prior to their lockout for relief from forfeiture. And if they had all of the funds and were willing to pay them all, and there was no opposition say that they were creating some form of a nuisance or something else, and it was strictly just a financial issue, the court would have no choice but to grant that relief from forfeiture motion. So I think we do have laws in place that are different from the state of Washington and reflect that as far as when a cure period ends and when the notice itself actually requires the vacating of the property itself. I would say the landlord's required to give the tenant at least, again, 3 days to cure the rent by that deadline, but again, terminates on the 60th day.
It's a foreign entity.
Again, the tenancy's not.
That's what niggas listen. Wait till I get in court. They're gonna be trying to like cut me off and shit.
In other words, it is the tenant's act of holding over.
They might not this time though.
And that requires them to vacate. And the tenant is not holding over until the deadline to vacate is actually expired. So accordingly, the use of the 3/30-day notice is actually consistent with the provisions of the CARES Act. And such notice does not purport to terminate the tenancy 30 days until 30 days after the service thereof. Given that there is no actual statement that they must be given that time to pay, I believe compliance is met by way of the 3/30-day notice. And then, Your Honor, I'm going to go into a little bit just sort of rebutting the defendant's arguments. And that those arguments in the Washington cases rely on the premise that Congress intended to grant tenants a full 30 days to pay the delinquent rent in addition, and that just isn't there. And that somehow this frustrates the intent of Section 9058 sub C1. This would require the court to deviate from the plain language of the statute or insert additional language or meaning into the statute in order to better carry out congressional intent. And it's clearly stated in the Lamey versus U.S. trustee case, that's 540 U.S. 526, that it is not the court's place to rescue Congress from its drafting errors and provide what it might think is a preferred result. And they're quoting from the case United States versus Granderson, which is 511 U.S. 23. If Congress wanted to give tenants 30 days to pay their delinquent rent before facing eviction, it should have said tenants must be given 30 days to pay delinquent rent, set forth in a notice to pay. At a bare minimum, Congress needed to include statutory language that could reasonably be interpreted as requiring tenants be given 30 days to pay. And they failed to do so. In addition, as I had stated previously, these issues are probably occurring across the country, and they've done nothing as far as amending. They believe that they knew if it was actually their intent, they would have done so. Again, the fundamental purpose being that the idea is to obtain those funds. I think the issue here is that the COVID-19 pandemic on a national level ended over 2 years ago. And the government imposed lockdowns that had prompted the CARES Act, the ones that were done on a federal level, have been lifted now for 2 to almost 3 years. None of the rental assistance programs, as I stated before, created to assist tenants with COVID-19 yet are still operating pursuant to this purpose. Again, I think it's important for the court to know that in Alameda County, we were under a completely different standard. We can't even go after these funds that are considered COVID-related debt. So to try to argue that what has now accrued after the moratorium is somehow in any way or can be COVID-related, I think is a farce. I think it's important to also know that Your Honor has herself ruled that we can't even go after those. If we present Your Honor with a stipulation that says we're even including those as far as an enforcement mechanism, any sort of COVID debt that occurred during the moratorium, Your Honor's found that to not be allowable. So the very idea that this is still going on, that the COVID-19 pandemic is still here, I think is the most absurd. And the final piece of the statutory construction argument is that we must give intent to the original purpose of it, not some sort of continuing purpose of the legislation or interpreting what that might be. It's clear that this was to aid people because lockdowns were happening, people could not go to work, they couldn't make money, and those rules have long since passed. In fact, we're a year on already more from our own moratorium here, which was far longer than anywhere else in the country, perhaps, except if you want to look and say the city of Los Angeles. I would then finally just go into the fact that the court's attempt to read language into the statute that by its plain meaning states nothing of the sort is a slippery slope. And the court would further have to interpret that Congress further intended that all of these non-payment notices also comply with all 18 different rent control and just cause ordinances in the state, which aren't mentioned in any way anywhere in the CARES Act of any kind whatsoever. So I don't know how we reach that conclusion. And by that same logic, we do have the ability to say in this state that you could give a 60-day notice if someone doesn't pay rent. Under CCP 1161 subsection 2, I believe it's B1B, that you can actually give a 60-day notice for somebody who hasn't paid their rent instead of going through the 3-day notice. Does that then imply that that is a 60-day cure period as well, on top of the 60 days? Because those sections almost mirror one another, stating that the tenant must be given 60 days to vacate. Finally, Your Honor, I would rest on just an equitable argument. I would ask that Your Honor, if you are in fact going to confirm the defendant, not to make this decision retroactive. To say from this day forward, everyone's on notice that this is the interpretation of the court, and any notices served after the final decision on this must be the 30/30. Plaintiffs in these cases have already been forced to wait for 3 years in order to even be able to collect rent. They've also now been forced to wait that 30-day period. I can tell you unequivocally that when those funds come in and they can get their hands on them, landlords take them. Doesn't actually result in eviction as often as I think people would state. I don't think it often, and just given the number of cases that I do in front of Your Honor, I think I have some level of credibility to say that that is true. I think it would be highly arbitrary to do that at this point, prejudicial to the landlords, which is exactly the reasons that the cases that I stated relating to vagueness and that common person doctrine say we shouldn't go outside. So, thank you.
Thank you. Ms. Bixby?
Yes, thank you. Just to pick up on Mr. Mayberry's last point, I also, and our office also has many cases in this court, and I can tell you that there are landlord and landlord attorneys who did understand the correct meaning of this statute, and I have seen many notices that give a full 30 days to pay or quit. So it's clearly not unintelligible. I would say, in fact, these 3 or 30-day notices are actually less common than notices for subsidized properties that give the full 30 days to pay or quit. So clearly there are landlords and landlord attorneys who have been able to read this statute and understand the guidance that it gives to landlords seeking to evict tenants from properties that are subsidized, federally subsidized, or backed by a federally backed mortgage, or otherwise, fall within the Violence Against Women Act. I couldn't fully understand if Mr. Mayberry is arguing if the CARES Act is no longer in effect because of the argument about COVID-19 ending. I mean, I think the fact that there are people in, I believe, the House that have introduced a bill to end the CARES Act strongly supports a reading that it is still in effect. Congress, at the time they drafted it, chose not to put in an expiration date on this subsection. They did put in one on the other subsection about, a full moratorium on non-payment evictions. And we should read in, omission from one section when they chose to include language in another section, we should presume to be intentional. So Congress did not put in an expiration date on the 30-day provision. They did put in one on the full moratorium on evictions. That strongly suggests that this statute is still in effect, as does the bill to end it. So while that bill to repeal the CARES Act, may or may not go forward, the fact is that it is currently in effect. And when Congress was originally drafting it, they made this provision broader with no end date to not be limited to whatever might be an arbitrary endpoint of COVID-19 pandemic. Perhaps they intended that people in subsidized properties should always be given a longer time period to pay or quit. And as to the discussion about it doesn't explicitly say pay or quit, I mean, as Mr. Mayberry acknowledged, different states have different sort of schemes for unlawful detainers and evictions. So Congress clearly worded this broadly to be implemented in different states differently. So I would not say that in states where there is no right to cure, that Congress necessarily intended a right to cure. But where there is a right to pay or quit, such as in Washington or California, that is how the statute should be implemented. It is an absurd reading, honestly, to say that they intended that tenants only be given 3 days to pay, but 30 days to remain in this sort of limbo period where it's unclear what would happen if they tried to pay, whether that payment should be accepted or refused.
I tried to
clear
pay.
that in states where there is,
My payments were
I
denied.
don't necessarily agree with Mr. Mayberry's
Because he
argument
said they
about
didn't come from a
the
financial
pay or quit
institution.
periods being
And
different.
I
I
keep
think they
telling him
are
on paper
clearly
Detroit
the
Demar King
same.
Trust is a financial
So
institution.
in
On my
jurisdictions where there is a right to pay,
it's all on
that is
file
the
at
same length of time
California
as the right
Secretary of
to
State.
vacate, that is what was intended to be extended to 30 days.
Those are the
I
facts.
will say I have not read.
I'm sorry, Ms. Bixby. One, I want you to slow down for the court reporter, but also the court wants to be clear. Are you saying that this 30-day provision applies differently in states where there is an opportunity to cure versus states where there is not?
Well, I haven't seen cases in those other jurisdictions where there is no opportunity to cure. I could see a reasonable argument in those other states that because there's no opportunity to cure in their eviction proceedings, that perhaps Congress did not intend to grant one. I don't know. I don't think there are any cases out of those jurisdictions. And honestly, I find some of those other states where there's no opportunity to cure to be sort of perplexing as to what the process of unlawful detainers entails. That was sort of a dicta argument. But I think it's clear that in California, where there is a right to cure, that it would be an absurd reading of the statute to say that they were only granted 3 days to cure, and then this sort of limbo period before the 30 days to vacate applies. It's much more sensible reading to harmonize the congressional statute with state law, that those periods be the same length of time. And that's analogous to actually, in the other case we have set today, there was a 10-day period. So in prior to the CARES Act, in many subsidized properties, Congress extended the cure or quit period to 10 days rather than 3 days. And so similarly, in those cases, the period is the same length of time. It's not 3 days to pay and 10 days to quit. It is 10 days to pay or quit in subsidized property. That long pre-existed the CARES Act, but the CARES Act extended that period to 30 days. I would just say that I think some of Mr. Mayberry's arguments were that, a landlord can give a longer period of time to vacate after the cure period ends. Perhaps they can, but the point is that the CARES Act requires that the cure and vacate period be 30 days. I think that is the most sensible reading of the statute. That is the reading that courts in other jurisdictions that have looked at a state scheme that did have a right to cure have adopted. I'm not familiar with what the rulings are in other counties. I don't think those have been produced, but even if they had, this court is not bound by what any other court in any other county in California does. Those are perhaps persuasive and we could look at them, but I haven't reviewed them personally, so I don't know what the rulings by those other judges say, and Your Honor is not bound by that. I would also say that, in unlawful detainer cases in California, they are to be strictly construed because they are summary proceedings. So any ambiguity, I would say, in this situation should accrue to the benefit of the tenant because they are summary proceedings, which otherwise benefit the landlord in their expeditiousness. And so I don't agree that there is ambiguity, but if there were, it should accrue to the benefit of the tenant because everything should be held to a strict standard in unlawful detainer summary proceedings. I'm happy to address anything else that the court wants me to address. I will confess I wasn't able to keep up with all of the cases that Mr. Mayberry was listing that weren't in the moving paper or in the opposing papers. I'm happy to read them if we were to take more time, but I have not been able to read them in this moment.
Thank you, Ms. Bixby. Mr. Mayberry, anything else?
Well, I think it's just an interesting argument that Ms. Bixby brought up, that any idea that Congress looked to the states and went through every state's eviction procedures at the time that the CARES Act came out, I think is somewhat absurd. This was something that was hastily thrown together in the face of a pandemic in, I believe, April of 2020, after everything had been shut down in mid-March. And to think that they had looked to every single state and to look to their eviction laws and somehow thought, oh, well then the state's eviction laws will just apply. Well, I think that only...
See, I cannot even be seen today.
30 days is actually correct, because if they said, well, if they get 3 days to cure, we're just going to put in there.
I cannot even be seen. We still on number 5.
I think they were trying to come up with something that could work in all 50 states, knowing that it's to think that the people who drafted the bill didn't know that landlord-tenant law in the state of California was going to say be different than in the state of Texas or the state of Florida or other places where it's clear that we have differing opinions on these types of things. I think it's far more likely that their intent was to come up with something that would apply across the board and say, look, we don't care care what your state says. You need to give them 30 days at least to vacate. Period. Not to cure, not to do anything else. We're not asking that you attach anything. We're not asking that you state that, you can contact Congress, at this phone number, at this address, this email address. Those types of specifics, they're not there. They're not there in any other form of the CARES Act either. So if you read the entire legislation as a whole, coming to that conclusion, I think, is almost impossible. Because again, you're talking about something that they're trying to come up with that works in all 50 states. Saying you have a 30-day cure period for states that don't have one, or 30 days to vacate, doesn't make sense. It makes sense to say, I don't care what happens, they're getting 30 days to vacate. You can apply that across the board no matter what. You can't do it the other way. And just to be clear, I just want to make sure that the court understood my argument about the bill to repeal it.
The court understood your argument.
Okay, thank you.
Thank you. All right. Ms. Bixby, do you have any final word to add?
Yeah, I mean, my response would just be to say that yes, Congress did write this language very broadly, and I think it was intended to apply to the many different unlawful detainer, forms of proceeding that occur in the different 50 states. So it is possible that the overlay on that, on different eviction proceedings, would look different in different states. And that is actually true in a lot of different subsidized housing contexts. The ways in which those subsidized housing regulations play out is different in different states, because different states have very different unlawful detainer, or whatever they may choose to call it, proceedings. And so, I mean, for example, in some states, you can only get a jury trial on appeal, and they try the case de novo. So, I think there's nothing unusual with a federal regulation playing out differently in different states, but I think it is a more absurd reading to say that in states where there is a right to cure, that time period would be different than the other 30-day time period in the notice. That is a more absurd reading of the statute than the one
I be talking to myself,
adopted, and the one that these
going
other
over this stuff in my
jurisdictions have
head.
adopted, which is that it
Bro,
needs to be
they're
the same
literally
time
just
period.
talking.
Again, Ms. Bixby, I just want to make clear, is it your argument that the 30-day requirement in the CARES Act is, in California, and say Washington, a 30-day notice to pay or vacate, but in other states that don't have a cure period, that it is just a notice to vacate?
And again, Your Honor, without being familiar with the state laws in other states, I can't affirmatively say that. I'm just not.
And this is why he
familiar with the
dude
statutory
going with
schemes in other
federal shit,
states.
like Congress, because
Believe that it
no
is
one has
easy
all 50 laws.
reading
This
that
is
in
why
states where
Uniform
there
Commercial
is a
Code
right to
exists.
cure and where
Uniform
there's a
Commercial
right
Code is
to
a set of
pay,
laws so
that
all
it clearly
states can
must
do
be the
civil
same time
business
period. I
with
don't want to
each
take a
other in the
position about
territories of the
the
United
statutory scheme in
States.
other states.
It's District Code 28.
Okay. Thank you, Ms. Bixby. The court will be taking this matter under submission.
Thank you, Your Honor.
We are now going to take a 15-minute recess.
They take recesses.
And so we will need to clear the courtroom for 15 minutes. We will return at 10:45. Thank you, everyone.
Hi, Your Honor.
Hello, hi.
So now they're taking a recess. So basically, when people is in court, they're arguing their positions and trying to come to a common conclusion. And when you in court, it's when two parties agree. That's when you get a fact. And this is the thing. I'm the only man with facts on Troy DeMond King Trust on this WA Ben. And this WA Ben is reporting human status for tax withholding. I don't have to pay the tax on that. And that's what they're trying to argue, that I owe a tax that I don't have to pay. And due to the Troy DeMond King Trust has a W-8 ban on file with the California Secretary of State. So I'm trying to figure out if you're withholding a tax due to using the security of Troy DeMond King, I'm owed money due to the United States District Code, Uniform Commercial Code, so all states can do business as a union because we're all doing business. If you got an LLC in Delaware and they're not paying, then they got another, it's owned by another one. And everybody is on foreign territories, bro. Like all these businesses, like they be moving around, and then you finally, for example, you can look up Navy Federal in your state, but then their corporate office is in a whole nother state. The reason that is even possible, hold on, I can come out to Zoom and go back in. Hold on. 10:45, we back in the court. $10:45, we back in court. Hey, listen, we do everything on these lives. Whoops, I didn't mean to go over there. We get to them. It says the burden of proof is now 1,000% on Ryan Garcia to prove where he got exposure to Ostarine. The strict liability rule requires him to prove that there was no intent to cheat. If he is unable to do so, I believe he will be fined and suspended by the New York State Athletic Commission. And then he tagged Devin Haney. Like, this is clown shit. But we already knew it was going to come back. What was the dosage, though? Breaking. Ryan Garcia's B samples results were overturned Thursday. Let's go. We positive. Patrice vibes. I fucking love steroids. Oh, man. New York Commission received the B sample testing report and already, like, it's hilarious. But we already knew that because Fact Check was in here saying it was already going to be positive.
This is bullshit. It's an inside job.
He on their back. It says Ryan Garcia B sample results were returned Thursday AM, one day after being open. I have reported that the lab B samples expected match the A samples, both positive, banned ostarine related to VADA test before VADA. What was the dosage of the B sample? That's the thing. We already knew that. It says Ryan Garcia VADA B sample results from the Devin Haney fight have now also came back positive for Osterine reports. But that's the thing. We already knew that. And the thing was, Fight Hub, Ryan Garcia's team issue. Ryan Garcia is committed to clean and fair competition and has never intentionally used any banned substances. Soon after being notified of his positive test, Ryan voluntarily had his hair collected. See, this is where the shit get real. And we only got a couple minutes to talk about it. This is where it get real. He had his hair collected. Remember I told y'all hair and blood. It's gonna be a wrap. I told y'all that. I told you, didn't I? I'll keep reading. Voluntarily had his hair. Oh, just keep that. Collected and shipped to Dr. Pascal Kentz, the foremost expert in toxicology and hair sample analysis. I told y'all. I told you. You can't just be talking pee-pee. You got to get that hair or blood sample. And he sent it to a toxicologist. And that's what I'm saying. It's going to be a bag when he take it to the New York State Athletic Commission. The results of Ryan's hair sample came back negative. Negative. See, y'all be reading everything, but nobody read this on Fight Hub TV. This is consistent with contamination and demonstrably proves that Ryan had not ingested Osterine over a period of time. The only way he could have had any advantage whatsoever in the ring. Ryan has voluntarily submitted to tests throughout his career, which have always shown negative results. He also tested negative multiple times leading up to the fight against Haney. All these factors combined with his ultra low levels from the samples taken April 19th and 20th in the billionth of a gram range. Like, what is y'all talking about on this shit? This is why I got y'all in the court, so we can actually understand that if you don't have a ground to stand on, bro, you just talking crazy. Like, what are you talking about? And this is why I said, anybody want to challenge the facts on a channel, we can do that. I'm not tripping. The sample A was in a billionth of a gram range, meaning it had no performing enhancing effects. Let's move on, because we in court today. Point to Ryan being the victim of a supplement contamination and never receiving any performance enhancing benefits of the microscopic amounts in his system. I'm going to read that again. All of these factors combined with his ultra low levels from the samples taken on April 19th and 20th in the billionth of a gram range point that Ryan being a victim of supplement contamination and never receiving any performance enhancing benefits from the microscopic amounts in his system. This channel is about facts. We are certain that one of the natural supplements Ryan was using in the lead up to the fight will prove to be contaminated and are in the process of testing these supplements to determine the exact source. So look, when it all come down to it, they testing the supplements and they tested his hair. If all of that shit come back negative, Devin Haney and them gonna get fucked up because they contaminated the samples, and that shit gonna come out, and niggas gonna be looking stupid. And that's the fact. And we see we got 4 minutes till it's time to go to court. And this is why I was asking to go to mediation with Judge Herbert. So yeah, what is we talking about? Because Fight Hub also posted some things. And this is what I keep saying. With this billionth of a gram, niggas is posting shit for sensationalism, to be sensationalized. So I'm confused on what niggas is talking about. Because we discussed the facts. And that's why I be on their backs. We got to get back in court. We might not. I might be able to be seen today, but I might not. But we definitely gonna be in there arguing. But they don't really be letting see. They let dude get off all that, and dude, and that's the thing. Now it's a statement settlement. So now he has to rebuttal and talk about those things. So that's what I be saying. Like I'm into the facts. I take all accounts into part. And when the test already came back with the billionth of a gram in there. So what is we talking about? We talking about facts, or because the facts I could read them again. And that's I've been telling y'all this the whole time. He already gave his hair sample. Ryan Garcia is giving a hair sample to Dr. Pascal Kent, the foremost expert in toxicology and hair sample analysis. I told y'all when you do a real test like that, you use hair. And it already came back. The results of Ryan's hair sample came back negative. Told you. You can't say I didn't say that. Hair or blood. Once you test that, then you know. Ain't no excuses. If you having problems with your PP and then you test the hair and blood and they come back negative, then you're free. So anything other than that is buffoonery because it doesn't hold any weight. You said he had a banned substance and it was in his system. That's why they be taking your hair. Ain't nothing but this hair is full of THC, CBN, and CBD and herbs. So you got to understand that they was here for the court and left for the boxing. That's on them. But we got to go back to court now. Let me go back in here. We back up in this courtroom. Yeah. They coming back in the courtroom. But yeah, Ryan Garcia's. See, this is all this is about court today. Court. Man, they taking all day. I'm ninth, but I'm just chilling. We talking about all court today. Boxing court with Ryan and them. And that's why we doing this, to learn.
Welcome back, everyone. Judge Herbert?
Yes, thank you, Your Honor. Unfortunately, the Tessima versus Curry matter could not resolve, so I wasn't able to get that one resolved for you today. Are there anyone else? Is there anyone else who would like to take advantage of this?
I'm going to actually see who's here and to see if we have anybody.
Yeah, I've literally been asking to see Judge Herbert.
Madam Interpreter, Mr. Bornstein, you know.
Because I'm trying to resolve it so I can go about my business.
I think so. Why don't you report back at 1:30? Yeah, thank you. Yeah, we'll need to tell Mr. Curry to report back at 1:30.
Hi, Your Honor.
Hi, Your Honor. Oh, hey. No, not now. Thank you.
They just coming in and a jaw. Your Honor.
Madam Interpreter, are you ready? Yes, thanks. Yeah, you can report back at 1:30. Yes.
So why they doing that?
All right, I know there are a number of people here who are waiting for their court trials to be called. And we still have a few long motion matters and a number of ex parte applications before we get to those court trials. But given the time, I do want to see who is here for their court trials and see if there's anybody who might be interested in mediation this morning to make good use of the time while we are waiting for your matter to be heard.
Pero primero quiero tomar lista de quién se encuentra presente aquí para sus juicios y también quiero ver si alguien está interesado en participar en alguna mediación.
And again, as I mentioned yesterday and have mentioned on numerous occasions, mediation and reaching an agreement with the other party is the really only way to take control of the outcome of your case.
Y como he dicho ayer, y de nuevo vuelvo a repetir, el participar en mediación es la única manera en que pueden llegar a un acuerdo y ustedes tengan control de la manera en que se vaya a resolver su asunto.
And through mediation, you may be able to agree to items that the court would not otherwise be able to award, including items like move-out dates or creating payment plans. Those things the court will not be deciding at the end of the court trial.
Y ponerse de acuerdo, ustedes pueden decidir cosas que normalmente no se podrían otorgar dentro de un fallo por el juez. Por ejemplo, no podría yo fijar alguna fecha para que se desalojen el sitio o la cantidad que tengan que pagar mensualmente. Eso no podría yo decidir. Eso es lo que ustedes pueden hacer por medio de la.
See, I'm about to put it on there. I'm about to be on them.
So before we jump into, again, law in motion or the court trials, what I will first do is call the court trials today to see who is present. And I will hear cases first by those where only one party is present, and then I will hear the contested cases where both parties are present.
Entonces voy a tomar lista para ver quién se encuentra presente para su juicio. Pero primero voy a llamar casos.
Yeah, so we're gonna see if we. Yeah, it's always remote court because I don't be going in these courtrooms, bro. I don't go in courtrooms, Mike Henry. I'll be on the phone remote. It's right here. Remember I told y'all.
There will be time to mediate. So if there are any cases where both parties are present, I will assign them out to work with Judge Herbert this morning.
So she gonna sign because I'm gonna try to mediate mine together so I can go to work. I got shit to do.
When the matter actually gets to trial, it will proceed by the parties first coming up to counsel's table, and plaintiff will sit on the side closest to the jury box where our interpreter is sitting, and the defendant will sit on the side further away from the jury box.
See, this is why this channel is about learning and facts. I know, my nigga, listen, I'm always gonna win because I'm getting knowledge, Mike Henry. There is no wins or losses. Look, bro.
Because the plaintiff has brought the case, the plaintiff will go first in presenting their evidence.
Hold on 1 second. Look, that the self has no likes, dislikes. I'm in truisms. My last name is Amin. I live expecting neither gain or loss, pain or pleasure from things I need in my life. Because my nature is essentially unconditioned. My nature is unconditioned, bro. And I don't even think about winning. I think about gaining knowledge for myself to get to the next level so I can educate others, bro. I'm here to educate others on top of doing what I'm doing. I already won because I found the self and I'm acting on the self. I need to get some cayenne in this. Truth above emotion.
Questioning a witness, please do not try to justify yourself or to argue with the witness. Just ask the question in order to get the information. After the plaintiff has presented its evidence, then the defendant will have the opportunity to present its evidence to the court. I will quickly call the court trials just to see who is present.
She calling court trials to see who present.
Thank you. Beginning, we've checked in on line 18. Hold on. Okay, line 23. The MP Arroyo Som Limited Partnership versus Wahidi. I know Mr. Danielle's here. Do I have Mr. Mohammed Wahidi?
Muhammad is in the building.
Line 24, Prime Tennyson versus Tam. Is this a contested matter?
It is, this was the day before.
Okay. Do you think working with Judge Herbert might help? Okay. So when would you like this continued? How many weeks? Is the 13th, we're dark, we can continue it to June 20th, which would be 4 weeks. Okay, this matter will be continued to June 20th at 9:30. Thank you. Line 25, Camden Village Apartments versus Ross.
They be killing me skipping
Nathan
around.
Ross or Jennifer Hodgson? Proceed as approve it. Line 28, Harrison Menlo Preservation versus Veda. We only have a few more matters in court trials, then we're going to jump to audition. Okay. All right. Do I have Harrison Menlo Preservation versus Veda? Nobody's on that line. We're going to continue that matter to June 20th.
Who knows, bro? They be skipping
Line
around.
32, Vasona Management versus Gonzalez.
I'm supposed to be 9th, but she already in 32. Like, why would you go that? They do this every time.
Line 33, Triwick Development versus Cosmotech College. I do see that both parties are here, but we are missing Mr. Tang. Yes.
I contacted Mr. Tang last night.
We about to see Jalen because we've been on here since 9 o'clock, bro. It's been 2 hours. They've been hearing cases. We've been hearing some bars. They talking about COVID relief debt. They got a lot of different things they talking about, but it's basically all the same. All of these are addictions, bro. So that lets you know it's a problem. They literally trying to get everybody out their cribs. Like, that's crazy, bro.
And he mentioned that by email to me that he was going to find the case. So I did everything I could to let him know that this is the time for the file.
When does he return, Mr. Sorba?
He mentioned 3 weeks. That's the email that I got this morning.
Okay, and do you know when?
Let me see if I can hit up this nigga
And he
Allen.
did not make a request to appear by Zoom. What I am going to do is I'm going to set this for trial on June 20th. I'm also going to set that date for an order to show cause for sanctions for Mr. Tang and his failure to notify the court of his absence or request a remote proceeding.
Your Honor.
Yes.
Also, it is obviously some prejudice to my client regarding money. The rent has not been paid, and we're talking about $160,000. Now, can you make part of the order that without waiving the 3-day notice that we served, they at least pay by the money for a continuance that is now given by the court based upon trans behavior during this matter, and also, Your Honor, that they're not doing a request for a jury trial requested, or that it is requested to be denied. And right now, discovery is closed.
No, yeah, Mr. Sorba, it would not be a timely jury demand at this point. So there will be a court trial. I am not going to require payment for the 3 weeks, but that is something that we will discuss in terms of the sanctions. So again, we'll put this on for a court trial on the 20th, as well as an order of show cause regarding sanctions. Thank you. Okay. Judge Herbert, it does not appear that we have any more matters that would be.
She lying. I just hit it.
For mediation today.
Oh, maybe I can't do mediation.
Thank you so much.
It's my pleasure. Take care.
Maybe I couldn't do a mediation.
Okay, moving on to line 6, Teo versus Dorsey. Or
yours?
I'm ninth.
Well, we're back.
Laura Bixby for defendant. I didn't get any notice of intent to contest the court's tentative, and I don't think anyone is present for plaintiff.
It does not appear so. So the tentative for line 6 will be affirmed. Line 7, Ashland Village Apartments versus Williams.
Good morning, Your Honor. Jane Gleason, appearing for plaintiff.
And Laura Bixby appearing for defendant.
Laura Bixby is with Alameda County Bar Association.
All right.
That's why she's handling everybody's cases.
Your Honor, I have printed out 2 things for you from my brief. One is a copy of 15 U.S.C. 905H. Do you have that in front of you?
She hitting.
Why don't you just submit the copy? I can pull it up, but it's easier.
CARES Act for the
15 U.S. code.
Yep. Thank you.
That's credit. 15 U.S. code is credit.
Ms. Gleason.
The first thing I want to clarify, if you were to find in either the plaintiff or the defendant's favor that the language in the order be clear, and on the first page at the bottom paragraph, it says defendant's motion is granted because plaintiff was required to give 30 days to pay the overdue rent. C 15 U.S.C. 9058C1. And I would just request for the clarity in the order and for the purpose of making the record that language actually track 9058C1, and it could say the motion is granted because plaintiff was required to give a 30 days notice to vacate, and the court finds the Washington cases persuasive. But to have the language in here, plaintiff was required to give a defendant 30 days to pay the overdue rent, that should not be followed by 15 U.S.C. 9058C1. So that was my first request, that just be clear on the order and actually track the language of 9058C1 that we're required to give 30 days notice to vacate. And then in the Penzon case that the court has referred to, I would say that I know you find that case distinguished, but the point I want to make today is that case also clearly misstates 9058C1. That case also found that the landlord is required under the CARES Act to give a 30-day notice to pay. For that reason, I thought the entire, and argued in my brief, the entire Washington case is invalid. It's invalid because it's based on the erroneous premise and assumption of fact and statement that 9058C1 ever required a notice to pay, a 30-day notice to pay. That's purely dicta that is in the Penzon holdings, and it does not comply with the CARES Act nor Congress's intent. There was no legislative history that I could pull up on Lexis. The only thing I can pull up is referred to in the second Washington case. So first there was the Penzon case in 2022, and then there was the next case was Pendleton Place versus Santista. That is a January 2024 case.
And in that case, I cited the reasoning in my brief and the reference to the Congressional Research Service. And that is on page 10 of my brief.
And this is the thing. In my John, dude.
In that case, I cited because.
In my John, dude got all my information.
In how the court in Washington is attempting to interpret the federal law, but not using federal cases. Not using any of the cases Mr. Mayberry
See, we in here talking about federal shit today.
Concur with, and without
federal law
cases, that is my argument also. They did not use federal statutes to analyze a federal statute. They used Washington. Even their own language about.
See, this is where I'm a bag niggas because I'm arguing uniform commercial code.
Because they started off wrong.
I have jurisdiction to Admiralty Maritime Law. Troy DeMont King does. And if you're trying this under Admiralty and Maritime Law, can I get my remedy with the Uniform Commercial Code, which is District Law 28? Also, it's been adopted by California and Colorado Secretary of State.
The U.S. Supreme Court about the CARES Act. It's the only case I know of, and that was the Alabama Association of Realtors versus the Department of Health and Human Services. And this case is the case where the Supreme Court said that the CDC cannot interpret the CARES Act and keep extending it. That only Congress
this is the
can
thing
make that
too.
extension.
When I start mentioning Uniform Commercial Code and how my name is attached to it because I got a financial statement, and then they're going to be asking me questions and I'm going to be saying, I'm asking because this is with prejudice, UCC 1308, because, hold on, let me make this smaller.
So this is a arm of Congress interpreting this statute. And on the first page, it talks
Not the legal notice. What am I looking for?
Protections under CARES Act Section 4024 are narrower in scope than proposed by some lawmakers and wanted by tenant advocacy groups. That they are arguably unprecedented action by the federal government in an area of law that has historically been reserved to the states. And that's what Mr. Mayberry pointed out. This was an emergency ordinance. Actually, it was enacted on March 20th, 2020. So that was at the very beginning of the pandemic. It also says here, also on the first page, and this is where I actually pulled the language from my brief on page 10 out of Absentia, the language Pendleton Place versus Absentia, that in contrast to section 4024B, and that's the 120-day moratorium, 4024 subsection C does not expressly tie the notice to vacate to a particular cause. That is a plain fact that anybody could read. It is not tied. All of the Washington cases try to merge B and C together and say that they're to be read together.
Champ, you should give law practice a try. You be on your shit. No, Mike Henry, I'm already attorney in fact. That's why I got a trust fund, a foreign private trust fund. Thank you, sir. I really appreciate that, bro. I'm doing it for the people, for the natural human beings. They're trying to learn, bro. I'm trying to do it. I'm doing it for the folks who she hearing the case right now because and right now they arguing the CARES Act and federal law. And that's the thing. Every time I've been trying to come in and argue my federal law points, they've been like racketeering me and then trying to evict me and do all these other things. But now is the day. And that's a fact. It's 11-11. And I'm telling you, it's a fact. So yeah, no, bro. Like this, what I'm saying. When I start talking about, I reside in Uniform Commercial Code. So that's why when I look at, for example, when I go here and go to my UCC financial statement, before I even go to my financial statement, it's two parties involved.
It is totally different. The purpose of the CARES Act, whether you're looking at the House resolution, which is House Resolution 748-212.
House resolution.
Or whether you look at the text of 15 USC Section 905.
See, they talking about that House Resolution 192 in different codes, meaning you exempt from taxes through the United States. And see, this is why they all been trying to invoke federal law in these courts. And every time I've tried to do it, they be on my ass about it. Like,
it is, and actually the Penn site is 901 and 902. They refer to the reasoning of the enactment of the American Rescue Plan as that would be more persuasive to finding Congress's intent. But this rescue plan went in and modified some portions of 9058 in 2021. It did not add a 30-day notice to pay to Section 9058(1)(c). It didn't add it under there. And so if this reasoning was sound, and they're saying that Congress went and re-looked at this in 2021 and we should look at this intent, well, we'll look at that intent. They did not alter 9058(c)(1). Again, on page 2, in your third paragraph on the tentative ruling, and here up above on the first page, you're talking about section 15 USC 90581. But in paragraph 3 at the top, you say section 4024C, and you don't specify where in 4024. I believe to be accurate, it should say subsection C, subsection 1.
see, I could not even be seen today.
And then it says that section requires 30 days notice only for evictions stemming from non-payment of rent. And I think that's a very confusing statement that needs to be clarified. Section 4024, as far as applies to this motion for judgment on the pleading, the relevant portion is C1. It's that my notice is defective. Not the 4024 may require 30 days notice, but I think we need to specify to vacate. And it's silent on the 30-day to pay. And again, you can say,
going to find as follows. But I think whenever, since we're referring to section 4024, it should say subsection C, subsection 1, so we have an accurate record for whoever's side, whoever ends up prevailing, that's what we're discussing here. Then you also talk about the alternative interpretation from the amicus in King that the throes of the onset of the pandemic initiated an expansive and permanent nationwide.
Yeah, Mike Henry, like this is where I'm on my shit for the people too. You know what I mean? For the natural people in the world, so we can know what's going on.
I'm just going to speak to California. It is substantially altering contracts in California for residential rental properties. If a landlord has to give a 30-day notice to pay, this is the evictions are supposed to be accelerated. They're an expedited process. If a tenant hasn't paid, you're immediately experiencing damages. So if there's going to be 30 days and no counting weekends and holidays, which is going to make it a 40 or 45-day notice, well, then the landlord should charge a security deposit of 4 times rent, because the court and the statute is exposing them to greater harm. Congress didn't speak to all the contracts for housing in all 50 states. That is the reason why. It would have created a mess. And that is what the CARES Act, the Congressional Research Service said, that it is a standalone provision. And in the Aspentencia case, that court, which was the second division, refused to expand language that Congress had not inserted. And I would urge this court to do the same. You didn't address the cases that I raised in my brief, and so I would like to raise them again, to find that 1161 subsection 2 should be changed now because of a federal act, and changed from a 3-day notice to a 30-day notice is a form of preemption. And I have the arguments in my brief. I won't repeat all of them. But the preemption would overrule a statute that goes back to the 1880s. I think that
She in the 1880s.
to look at instead of California law.
They're trying this is some real shit. They're challenging California law for housing.
Where the housing authority was just going to change on its own during COVID and give a 10-day warning notice before the landlord could get the 3-day 30 notice. They wanted a 10-day warning notice. That was struck down. The reasoning in that opinion is all California law, and it is very sad. And then I also had in my brief the Los Angeles case, which I thought was also very good reasoning, and goes back through 100 years of California law. Why we have a 3-day notice, what the importance of the 3-day notice is.
They're arguing California law, saying a 3-day notice is or not enough time to execute an eviction or a pay to quit when everybody else gets 30 days and
I think that the argument that the defendant made
page 5 of my brief, in the middle of my brief, and I list all of these, and approximately 12 and 13 were changed. But they did not change 1162 subsection 2. So again, we're being asked by the defendants here, the court is being asked to make up some new law that the CARES Act did not require. When Congress went back and added in sections in 2021, they did not put in a 30-day notice to pay. They're asking for the court to do something to change 1161 subsection 2. They're asking the court to change something that the LA courts declined to change that section.
Now they bringing in other counties and
San Francisco court and the California legislature. So what are they exactly trying to do and get by with? What do they want to go on in Alameda County? The legislature in California hasn't done it, but they're asking you to do it. And the Congress didn't do it in 2021 and add a 30-day requirement to pay, but they're asking you to do it. So
this is over right now. This is a lot of these is over a 30-day notice to pay, and they're arguing that you only got a 3-day notice to pay and quit. And then the plaintiffs and defendants are saying that they need more time than 3 days.
Thank you, Ms. Creason. Thank you. Ms. Bixby.
Thank you. So during the break, I was provided with a ruling from Sonoma County. And of course, it's redacted because unlawful detainer cases are masked, but they reviewed a 3 or 30-day notice and found that it violated the CARES Act. And it was a very helpful ruling for me to review because I've revised my previous position. And I actually do think in all 50 states, the CARES Act does require an opportunity to cure, to pay or quit within 30 days. And the reason for that is the main thing that this Sonoma County decision rested on were HUD's implementing regulations, which were amended after the passage of the CARES Act. And specifically,
The CARES Act is the COVID Aid Relief and Economic Security Act, established the Higher Education Emergency Relief funds. He says, man, I didn't even know about half the stuff you was talking about, but I was tuned in.
Was added and states, in the case of failure to pay rent, if the
No, bro, it's all good.
determines
It's
that
just
tenants must be provided
this is about law. They telling you.
secure federal funding that is available due to a presidential declaration of a national emergency. The termination notice must provide such information as required.
A condition of receiving the Emergency Student Financial Aid Program, the CARES Act funding, the right institute signed to return to the Department of Education. The CARES Act is about COVID.
I think it sheds light into both congressional intent and HUD's, the agency's interpretation of the CARES Act, which is that, as the court brought up before, the 30 days was designed to allow tenants additional time to seek rental assistance and cure the default before the time to quit expired. And so if there was no opportunity to pay or cure during those 30 days, then that regulation would make no sense because, as it stated, the reason 30 days needed to be given was to allow tenants the opportunity to apply for rental assistance. Now, of course, there are some considerations of the fact that, the pandemic has waned, although perhaps not ended, but Congress has not taken action to end the CARES Act. They didn't put in.
They saying the pandemic ain't even ended.
And there are still rental assistance programs that tenants apply for.
You know how I know that? Because when you go in certain federal buildings, they still got on fucking masks, bro. Especially out here.
That sheds light on both congressional intent and the implementing agency HUD's interpretation of the CARES Act does suggest that in all 50 states, perhaps stating that if you are meant to read the subsection C, in isolation, that it would apply to all unlawful detainers, not just non-payment. And I'm not sure if that's actually the position she wants to take, because I would potentially welcome that interpretation. I'm not sure that that is necessarily supported.
And it's the crazy part.
The statute as a whole.
Man, Mike, man, these niggas be they be talking through this shit, bro. I might not even get seen today. They do this shit every time, bro. The crazy part is, if you look at the chat, I keep saying I want to see Judge Herbert. They ignored all of it. Evidently, my case wasn't able to be seen by Herbert. Look, these are the people in the courtroom.
Commerce Clause, because there's the federal purse at issue, because these properties are receiving federal funds in some ways. That's why Congress has the power to act in that space in the way that they don't necessarily have power to act over landlord-tenant relationships where federal funding and federal mortgages are not involved.
So if they don't see you today, how?
30 days notice to pay or quit is required in every
Hold on, let me, because this little
case in California. That's
thing is
not
in
our
there.
position. And I believe also Ms. Creason seemed to be arguing that Congress, in fact, can't lengthen the ability.
So if they don't see you today, how far back would they push your case? Who knows?
Because the notice in this case was pay in 10 days or vacate in 30 days. And again, that's because there was a previous statutory scheme that I referenced that in many types of subsidized housing, they were required to give 10 days to pay or quit rather than 3 days to pay or quit. So Congress knows how to act in this space. It has acted in this space in the past, and it chose to sort of expand its presence in this space when enacting the CARES Act. And they certainly have the authority to preempt state law when there is a connection such as federal subsidy. And for that reason, I think the cases that Ms. Creason cited are not relevant to this context, because the San Francisco and Los Angeles cases were about when.
So that means that you'll stay in your apartment and they're going to continue to harass you until you get back to court to solve your case then. Yeah, but this is the thing. I also got United States cases on them. So if they could listen, that's what I'm going to tell them. They could do all the dumb shit they want. They could do all this dumb shit they want to. But when it come down to the United States court cases I got going on these lawyers and these same people, they going to be in the bag. Ain't going to be no waiting. Then I asked for a jury trial. As soon as they have to answer to what's going on, they ain't going to have no answers. So that's why I ain't even tripping.
Promulgates references the CARES Act as a possible defense. That's not binding case law in any way, but it's certainly an acknowledgement that in some contexts, the CARES Act can apply in California. But I would really rest on this regulation and my position that actually congressional intent was to give
Because
to cure or pay and quit in all 50 states because of the opportunity to apply for rental assistance, and that regulation makes that clear. Thank you.
Thank you.
I never even had 30 days.
Yes, Your Honor. Briefly, the handout I gave you on 15 U.S.C. 905A does not reflect that regulation. And as you can see from the top, this public law.
She arguing like, no, they got to get up out of here. Like, all of this is about people trying to get money in certain ways because they don't know how to deal with their fucking taxes. They don't know how to write shit off and get it an income tax as a loss. Because when you do that, because you're working to provide housing for someone else, you could write that off. Like, they're not trying to write it off so the government and the Fed Reserve can recoup them the money through income tax so they can continue to pay to keep somebody living. What they're doing is trying to compel the person to pay them money. And that's what they're trying to do to me. I'm not compelled to pay for anything for Troy DeMond King Trust. I'm not compelled to do it. It don't matter what you say, how you say it. I filed my American States Assembly paperwork with the courts. And now dude acting like that court work don't exist when it does.
So that was already built in. That doesn't mean it happened in this case.
And in my case, dude is basically saying in plain terms that none of my paperwork is on file and exists and all of this, which is just cap. I gotta turn these in. It's greasing. Greasy.
The court will take this matter under submission. Fair Honor, trial is going to need to be, yes, we're going to need to continue the trial. Okay. So we will continue the court trial in this case. I'm going to set it to June 20th, which is a Thursday at 9:30. To give the court some time. Thank you, Your Honor. Thank you.
You're about to see.
That is it for our long motion calendar. Yeah.
That was long motions.
Line 8, Warren versus Lazzarini. We have Stephanie Warren here.
I'm next.
No, that is what you said, but we do need to set this.
I'm next.
For the hearing. Well, the
I'm next.
court will be dismissing this matter. So the court can't provide you with legal advice. We do have a handout that you can with legal resources. So the court is going to be dismissing the case, her complaint.
They're not even gonna listen
And
to it.
then there may be that the court can't give you legal advice. So you can talk with self-help or reach out to the resources. But on line 8, the case is dismissed.
Line 9. Yeah, it's me.
Line 9, Hardy versus King.
Good morning, Alan Horwitz on behalf of the plaintiff.
Hamza here on behalf of the defendant.
Amen. Thank you. So I will note for the record that Mr. Amen is also the same individual as Troy King. He prefers to go by Mr. Amen.
No, I'm not Troy King. I'm not Troy King. It's a separate individual foreign entity. I'm not Troy King.
Mr. Amen.
Yes, sir. Yes, ma'am.
The name designated at birth, is that Troy King?
No.
Are you not the defendant in this action?
No, my foreign private entity is the Troy DeMond King Trust. It's filed at the California Secretary of State under entity number 20222-051260.
If you, sir, are not the defendant in this action, and you are not Troy King, then you have no basis on which to appeal or participate in the settled statement hearing today.
That's not what it states in the actual paperwork I have on file with the court. I've revoked all powers of attorney. It's my person.
Okay, so I understand that you filed a number of papers with the court and that you believe those papers have a specific legal meaning. However, this is a court of law, and the individuals who have standing in this case to appeal and or participate in today's settled statement hearing would be Troy King, as well as Mr. Hardy and his representative. Now, I understand that you prefer to go by Mr. Amen, and the court is fine referring to you as Mr. Amen. However,
if you are indicating that you are not the defendant in this action, we will proceed without you.
That would be proceeding with prejudice because I'm literally informing you that the party of the first part is Troy DeMond King Trust, the copyhold trust estate bailer, under any and all derivatives and variations, spellings thereof, with the exception of Hamza, under account number 2938 and 3545, with all property lawfully part of trust, held as a foreign trust estate, according to 20.
Let you know that
Okay.
that has no legal meaning in this courtroom.
Okay.
Are you the defendant, sir?
Troy DeMond King Trust is the defendant. And
No,
I
the defendant.
and I'm the
defendant is an individual.
and I'm the
named
executive
Troy King.
administrator of the trust.
The defendant is an individual named Troy King. I need a yes or no answer. Are you the defendant in this action?
No, the Troy DeMond King Trust is the defendant.
So that it is the court's understanding that you do not want to participate in
No, Troy
today's
DeMond King Trust wants
hearing.
to. Troy DeMond King Trust wants to participate. I'm speaking on his behalf.
No. So that's not how it's going to work today.
Okay.
I need you to turn your video on.
No, I don't. I'm private. I have no surety in this matter because I'm the party of the second part, the secured party for Troy DeMond King Trust.
Okay. I'm going to let the record reflect in the minutes that the defendant, Troy King,
Troy DeMond King Trust
has not indicated that he is present.
We've been swearing in since I've been doing this in this Troy DeMond King Trust and the executive minister.
We have not been swearing you in as a trust, sir. We will,
Well, that's what it is, but I don't know what else I can do. It's on file at the California Secretary of State, so I don't know what do you want me to do. The evidence is there.
Whether it is on file with the California Secretary of State, and frankly, if you are an entity, then you need to be represented by an attorney.
No, I've revoked all powers of attorney. It's in the legal notice in demand.
I understand that is your position. I will tell you that is not a recognized position in the court of law.
What?
So
can I ask a question?
I'm going to ask you right now, sir, would you like to participate in the settled statement hearing, or would you like the plaintiff to
can I ask a question? What are you attempting to try this under? What law?
Excuse me?
You
filed.
I'm asking a question. Is this being filed under common law?
Interrupt the court, sir.
Okay. See, they don't be wanting to let me talk.
An appeal. And as part of your appeal, and I will note, sir, that you are putting yourself under the jurisdiction of the court when you do file an appeal as Troy Hardy.
I'm not Troy Hardy.
Okay. So currently you filed an appeal.
No, Troy DeMond King Trust filed an appeal.
Well, that individual was not a party to this action. And the court
according to Troy DeMond King Trust, any derivative name of Troy DeMond King Trust is a party.
I'm giving you every opportunity to state that you are the defendant and that you do want to have due process and that you do want to participate in this proceeding.
I am participating in this proceeding on behalf of the Troy DeMond King Trust.
You need to unmute yourself, sir, and I need to know if you want to participate in this as the defendant.
Can you hear me?
Now I can. Will you be participating in this as the defendant, Troy Hardy?
I am not. Why do you keep calling me Troy Hardy?
Okay.
I'm participating on behalf of Troy DeMond.
I'm sorry, Troy King.
I've kept stating that. Why are you? You can't even get my name right. I'm participating as Hamza on behalf of the Troy DeMond King Trust because it has a Dun and Brad's, a EIN, an entity number, And that's all it is. And that's all I can do at this point, ma'am. I can't do anything else. I'm operating under Uniform Commercial Code and federal law. What do you want me to do? That's admiralty and maritime law in a corporate courts. I'm just.
Sir, this is not a commercial transaction. What it is a court of law. And you have filed, or Troy King has filed an appeal in this case. And has
Troy DeMond King Trust is the name.
Well, then the court will need to deny the appeal because Troy DeMond King Trust is not a party to this action.
So who is Troy King? Because that you're telling me what my name is when you have no facts of that.
The court is not telling you who your name is. The court is telling you who the defendant in this case is.
No, but I never put Troy King on any of my paperwork. I'm always listed as Troy DeMond King for his paperwork. So when you put Troy King on, that's just a derivative of the copyhold trust name. I'm looking at the paperwork for Troy King.
Mr. Horwitz?
He has all the paperwork.
Excuse me, I'm asking if he has.
I think to add, Your Honor, I don't even know how to respond to that.
Of course he does. Listen, they never know how to respond when you got facts. I'm looking at the paperwork right here on my John.
I will note that the party who requested an appeal, the appellant is Troy DeMond King. I will refer to Mr. King as Troy DeMond King. So, does Troy DeMond King present and seeking and Troy DeMond King, I will note, is the individual in an individual capacity who filed the appeal, and I'm looking at the paperwork as such. So, does Troy DeMond King want to have any input into the statement on appeal?
Yes, Troy DeMond King definitely will like to have input statement on the appeal.
Okay. And is Troy DeMond King present?
Troy DeMond King is present right now.
Great. Okay. Mr. Horwitz.
You see how I got to play with him? He never knows what he's supposed to be doing. So who got bodied?
Sort of ability to make any sort of comment on a statement of appeal.
He can't even comment on the appeal.
I oppose what he said. He's put in plenty of arguments that are not proper in appeal, that don't relate to the actual properties of the case, and I'm not quite sure what the court is asking of me to do.
He don't even know what to do. They're asking him to explain the paperwork I got on file.
There's a process by which one party submits a proposed statement on appeal, then the other party provides a response, their own statement.
I'm not a sovereign citizen, Casey. If you don't understand what's going on, you got to go, blood.
First,
we'll put you in timeout for 24 to hear.
By Troy DeMond King on to you, Mr. Horwitz. And so the court at the last hearing realized you did not have the opportunity to provide that response and to provide another statement. So the court
now he got to provide a statement that he don't want to provide because he don't want to adhere to the paperwork.
The only thing I've put in is just an opposition stating that I disagree with what he stated on there. I've not put in my own statement. I really don't.
He don't even have a statement.
He wants to put in for an appeal. It doesn't bother me one way or the other.
Okay. Does Troy DeMond King have a response?
Troy DeMond King definitely has a response, and the response is, I was looking for rebuttals to any of the affidavits that were on file in the paperwork, as far as the American State Assembly of paperwork, and also have a notice of lien that I've mailed to Alan Horwitz, and I've also have on file the Colorado Secretary of State because Troy DeMond King has his property liened for commercial activity purposes.
Okay, so sir, none of that is relevant to this appeal.
Okay, so what's irrelevant to the appeal so I can argue my case?
You're not arguing your case on appeal, sir. We are trying to pin down a statement on appeal.
Okay, what statement did you need from me on the appeal?
You've already provided a statement.
Okay, well, I'm looking to hear from Alan. What he got for us?
Okay, so Mr. Horowitz did provide an opposition already. The court will take Mr. Horowitz's opposition as well as Mr. King's statement.
He don't have no opposition.
And the court will draft its own statement of appeal, a proposed statement of appeal to be submitted to the parties within 10 days.
Thank you, Your Honor.
Thank you.
I have a
Maybe I can make your calendar just a tad bit easier. Line 15, I think I'm on also for ex parte application for judgment.
And I believe there are no papers in that one.
Oh, really?
Let me just check.
See, that's why I be playing with him. I'm not Troy King.
Wait, hold on. Okay.
They muted
No, we
me.
did have papers in that one. Sorry. Okay, online.
I'm not Troy King, no matter what they say. You can't tell. See, this is what y'all don't understand about court. They really try to tell you that I'm Troy King when I put Troy DeMond King on the paperwork. And they want to, now let me see you. No, you don't need to see. They didn't already. Look, they moved on. See, I be trying to tell y'all. The court wanted to talk about this shit now. They don't even want to talk to me. So who's Pat getting busted? He didn't even have shit to say to the appealed statement. They keep asking him, what do you have to say to the statement? I don't know what to say. I don't know what to say on this statement in the matter or none of that.
Thank you. So I understand that the plaintiff filed its application based on the assertion that the defendant.
And that's it. That was it. Every time I'm in there, they never even have shit to say. As you can see. No, I'm not Troy King and say on this paperwork right here who Troy King is. And that's why I was reading it to y'all. It's a copy holder state or trust. I'm Hamza. It's actually filed as a business. Then on top of that, they were trying to tell me I was Troy King when I'm saying I'm Troy. How the fuck? Hold on. See, this is the thing where y'all don't understand what I'm saying. And this is where your pack is going to get busted. If my name is a business and my name is Troy DeMond King right there on the social security card, how are you telling me my name is anything else? How the fuck can you tell me what my name is and how I filed? See, that's what I be trying to tell y'all. They never have anything to say. They don't want to even try to rebuttal my shit. That's why the nigga ain't got shit to say. He got, hold on, I'm going to find the paperwork that he wrote. Because I've been reading it to y'all. It's clown shit. He don't have nothing to talk about in there. Because when I put the appeal through, he can't rebuttal. He can't rebuttal none of the shit I put in. He's just going to say it's not relevant to the case. I don't know. Because he doesn't fucking know. That's what I keep telling y'all. He don't know shit. And listen, that's what they say. They don't want to talk to Troy. They don't want to talk to Hamza in this type of court because then they're going to be like, no, it's not commercial. Well, what is it? Are you trying to try this in Admiralty Maritime Court? She didn't even want to let me get that off. That's why if y'all would have showed you her face, she was on there smiling. Like he trying to, yeah, what did you trying to try this under? What are we doing? You're not telling me nothing. Oh, he has to respond. Oh, the proposed settlement statement. All right, this is the settlement statement. What do we got to say? I ain't got shit to say. Well, then it's settled on my behalf. And if the courts make any decision not on my behalf, it's them. So when niggas be like, you ain't Hamza, hey, blood, you can't the courts can't tell me who the fuck I am. That's why they had to just listen. It's Troy King. That's why she, listen, if you listen to the shit, that's why she fucking reworded it. It's Troy King present. Troy DeMond King trust. Yes, he's present. Do you want to speak with them? All right, speak. Yeah, Hamza gonna speak for him. Yeah, you want to speak for Troy DeMond King? No, Hamza filed it on behalf of Troy DeMond King Trust. If you look at this, is my name in all caps? Thank you. That's not, look, I'm gonna show you something else. Y'all niggas gotta stop talking, blood. You gotta stop running your mouth on here. You see this? Lawful name. You see, is it in all caps? Now look at this. All caps. All caps. Now, do you hear how everybody else in the courtroom was talking about 15 U.S. code this, and then when I get to talking about it, it's like, no, that has no relevance in this matter. Oh, it don't. Oh, okay. Oh, it don't. Oh, okay. Well, why did I put that on a set? Look, hold on, I'm gonna show you. I put it in the proposed settlement statement. That's the part where niggas just be violating and doing dumb shit. So when dude on here, you got your pack. No, nigga, you don't know what you talking about. That's why you on here fucking watching, Wayman Casey. You watching, trying to learn law. As I showed you, once you come in the courtroom, no, you not Troy, you Mr. Amin. She started out with Mr. Amin. And that's the thing, she's lying because they swear me in before. That's why I explained this shit to y'all on here. I literally explained it on here. They actually swear me in as Amin several times and ask him, is this my given name? No, that's not my given name. The fuck you mean? It's a corporate name. It's on file. It's a commercial matter. It doesn't matter what you say. What nobody say in here. That's why I keep telling y'all be in fear of these niggas. I'm not. I don't give a fuck. Y'all niggas might be in fear of that. I'm not. When I tell you this what my name is and it's filed, that's what it is. And I'm about to show you. Yeah, you keep calling me. It was good. I was in court.
Oh, I thought you were done with court by now.
Did I tell you I was done with court, mother?
You don't have to tell me, smart ass.
Why wouldn't I have to tell you I was done with court for you to be able to call me so that you could talk to me and I'm be done with court? Why wouldn't I have to tell you?
I thought they called you and did your little thing on.
I'm gonna ask you again, mother. Mother, calm down. I never told you court was over, Ma. I love you. I never told you court was over. I was ninth. You can't assume because you was interrupting while I was in court while you were calling. Don't assume that you know. Yeah, like I'm in court and then I just want to. I'm live in court on the live because I need witnesses. No, I'm not doing it for that. I'm doing it so I can actually have witnesses because don't nobody be witnessing this stuff. I need to put it on some type of public record. You don't understand how court go. I have to have it on my own public record because they be in court telling me I can't talk for Troy DeMond King, just like saying you can't talk for LP Rogers.
So you still in court now?
No, I'm done now because the lady for about 2 to 3 minutes, she was like, listen, Troy King. I said, no, Troy King didn't file anything. Troy DeMond King filed it. And you guys have changed my name on the paperwork to just Troy King. And they didn't even want to hear to that. And then I said, I'm Hamza. She said, Mr. Amin, Troy King filed. No, Troy King didn't file anything. I'm the executive administrator. She was like, well, we ain't gonna be able to hear you. Is Troy King? Yeah, Troy King is present. He's here with me right now. That's what I told her. She said, okay, fine. Because she knew what I was saying, and she was going to be in violation if she didn't let me speak.
Okay, and then what else you said?
And then she going to say, okay, well, we want to talk. I said, yeah, Troy King is right. She had to reword it, and she said, Troy King is here. She was like, is Troy King available to talk to? Yes, Troy DeMond King Trust is here. What would you like to talk to him about? And then she starts saying, well, the proposed settlement statement is set. You already said it. You made your statement. And the attorney had to rebuttal it. When we get for his time to have any rebuttal for that, he had nothing to say. He couldn't even rebuttal. So them trying to evict me, them trying to do all that shit they was doing, he don't even know what my paperwork talking about to even rebuttal to my statement in court as my appeal to the eviction.
So you get to stay there until what?
No, I'm already in here. And I didn't change my locks. Yeah, I don't know what he gonna probably text me some information, but they didn't really say nothing. They didn't say, well, we're gonna relieve this. What she said was the court will make a decision on the matter after all the paperwork, because they was like, well, the proposed settlement statement on the appeal was going, and then basically I put some laws on the statement, indebtedness, and then that means they're gonna have to. He didn't rebuttal the statement. He never had anything to say about my appeal and how I didn't even get my court case in court to argue. He argued. She asked him because this the thing, he sent me this saying, my things I'm arguing are not fact because I wasn't in court to argue them. And that's because I told you I was supposed to get a trial by jury on March 4th, but then they had court without me like they tried to do today. But then she had to reframe her statement, saying, it's basically saying, listen, I basically know what you're saying. Is Troy King around? Because we need to holler at him. We can't talk for her. And I kept saying, no, this is a commercial transaction. It's not commercial. She trying to tell me it's not commercial, meaning my name is not a business like our grandfather, like your dad's name and my grandfather. That's what she trying to say. She's trying to say she not even trying to adhere to those facts, because in a proposed settlement statement, I put certain laws in there that acquire me to get my money back. And then when the lawyer was like, I don't even know what he's saying. I don't know what he asking for. I don't know. He don't even know. He has nothing. He said, I haven't even put together anything on my own, because the last thing he wrote was all the paperwork I mailed to him through FedEx, that I got the number from Spunky, so I can mail him things next day. And the things I put on file, they saying none of that is relevant, when the trust documentation I put in the appeal is relevant. Because in the appeal I want to talk about trust documents and these certain laws. And then when I mentioned them, she said it's not relevant. Well, how is it not? I put it on the appeal form. So I don't know. Listen, they do what they listen. They're gonna try to do what they want to do anything but be able to adhere to facts. And I've already done it in United States court, so I really don't. I'm really not caring. So even if I gotta put my stuff in storage, I got a job.
That's what I was going to say. When do you start your job?
I started yesterday. I'm on my work. I'm waiting for my dude Dion to come today. I'm already working. I got 2 events I'm throwing. I'm throwing a sparring event June 1st. We need 10 matches. We need at least 10 3-minute rounds. And then I'm throwing a sanctioned amateur event on August 3rd at this gym that I'm basically the project manager and head boxing coach and trainer of the East Oakland Boxing Association, which is funded by the city of Oakland. It's a nonprofit.
Oh, okay.
You see what I'm saying? So these people could be doing all of this they want. Now, my director that I told you, she's from Ohio, and she talked to the mayors and all them people all the time. They got to do with housing and all of that. I'm not even tripping off these people, but he didn't even rebuttal anything that I had. I'm waiting for Dion to come right now, because the gym I'm run, the memberships you could pay weekly, and you could pay $12 a week or $45 a month. And she's looking for me to give her instruction on how to set up the infrastructure. Well, just how to set up the schedule of the gym, you know, like when people, yeah, all of that. Like I'm the boss now.
So let me ask you this. So she got pool that she can get apartment or housings or anything like that, huh?
Listen.
Or she just dealing with the.
Yeah, she got that type of pool. And then listen to this.
Okay, that's all I'm
No, listen, this the type of pool she got, because I got to give you an example. It's a park around the corner from 98th Street called Elmhurst Park. The city gave her the park for $1.
I know, you told me yesterday.
You see what I'm saying? That's the type of pool she got. So now, if she's the executive administrator and I'm the project manager and the head boxing over the boxing gym, which is the community, it's like when I used to live in Columbus, all the boxing gyms were in community centers. So like now this is dealing with Oakland, and now I'm in the community center of Oakland. They got a garden back. They got a garden back there that I'm gonna have to be a part of. They got a garden in the back. They got showers, boxing gym, and classrooms for me to teach about vegan diets and a full blown chef's, like a real regulated kitchen. And she's wanting me to teach and cook vegan meals and do all of that. I'm done. Like, I'm not thinking about these people like that. They don't even have nothing on me.
Okay.
Yeah,
I
so
want to know about the job.
yeah, no, the job is going. I'm going today. I'm about to make sure one of my little young bro, he could pay us $12 for this week, and then we training. Cause he gotta actually fight. He gotta do the sparring event, and he gotta fight on the 3rd. And this is my program. I could bring in who I want and talk to her like, no, we don't need them. Like, they're not good for. And I'm using the laws of God when I pick people. So you got to have a certain mentality. You can't just be coming in thinking you got to be some type of and following some type of religious acumen or something like that. Because I don't need people in their emotions when I tell them to do things. But you have to have some laws that govern you, so you can. I know you breaking your own laws, bro, with these kids in this community. So that's what we about right now. So I talked to Dame about it, saying if because this is basically Damian Lillard's neighborhood.
Oh, is it?
Yeah, kind of. It's like East Oakland. I'm in East Oakland. It's like deep East Oakland, where it's like black and brown poverty, like that type. Is in deep East. Like they call that deep East Oakland. Like, and East Oakland is famous. That's where Too Short and all of them from. So like I'm working in something different now because now I gotta reach out to Mr. Fab. I gotta reach out to these guys who claiming they, Oakland Red, the Warriors, like different people like that. You know what I mean? So we can get funding on behalf of the nonprofit and the boxing program. You know what I'm saying, Ma? Yeah, so that's my job now. Like, that's why I would literally I'm telling you, I was about to be back at the house in Darshan basement, fixing it up, doing the same thing with the boxing program. But when I tried to leave, God put it together, the supreme being. No, it's a lady from Ohio that's over here. Go talk to her real quick, Troy, the Mind King Trust. And that's what I was telling her about today. Like, what's gonna happen, because I was arrested last year for a false accusation and they put a felony, said it for criminal threats. And I was kind of emotional, and she was like, Troy, what's going on? Like, I'm like, ma'am, I don't want to lose my position over a fictitious any. She was like, well, we just got to be positive. Like, I'm like, no, I'm positive, but it's just like, I'm telling you the facts, and I don't look at my emotion in any type of way. It's just saying, like, I'm literally in court about this when they saying I have firearms and I'm trying to rob a bank, and then they put a felony. She was like, well, it's not a violent. She was like, if it's not a violent felony, you should. It was criminal threats. You know what I'm saying? It was a felony, but I never was convicted or anything like that. She was like, if you was never convicted.
They can put what they want. If you never convicted, they can't do nothing. And when you go for your taking your background checks and stuff like that.
That's what she's saying. They doing a background check.
Whatever background check, long as it's nothing that you killed nobody, you did nothing to somebody, then ain't nothing they could do, honey.
No, I'm just I tell people ahead of time so they not looking crazy.
You can do that.
Yeah, and that's all I'm saying. Like, I was just letting them know ahead of time, like, no, this was going on. And I even told her, like, when I sign up to work, I'm gonna use my EIN number. Like, I'm not, you're gonna be paying the Troy DeMond King Trust. I don't take any money directly anymore because I can't. I can only take the money directly from Troy DeMond King. Just like you can only take money from LP Rogers. Only you can. Unless you, on behalf of LP Rogers, are paying somebody who done an independent contracting. And that's what the judge is trying to say. No, the Troy King is an individual. Yeah, I know it's an individual, but it has an executive administrator. Just like she's the executive administrator of that court room, right? Then just like you're the executive administrator of our grandfather. I'm gonna call you back, my client here, my home. Yo. No, I'm done. You outside? Alright. Yeah, no, I'm done. We about to get ready to drive over to the gym and end this live. They ain't even had nothing to say. He couldn't even rebuttal my appeal paperwork.
Damn.
He didn't even rebuttal it. And then the courts was like, they gonna make their decision. And that's the thing. When you in court, if you argue on one thing, that's why I kept asking her, what are we arguing today? What's the proposed settlement statement? She was like, you already made the statement. Oh, okay. I made it on a piece of paper. And that's the thing. They going off what's on that paper. The paper that I put in and this is why he confused in court, because I was in that hoodoo herbs and magic on that calendula. He like, I can't got nothing to say. And a nigga in my chat talking about you got your pack busted, you ain't Troy. Hey bro, you can say what the fuck you want, my nigga. I know what I'm doing. That's why they didn't have no rebuttal. If they had one, you would have heard it. Nobody ever be having rebuttals for anything I fucking have to say. I'll see. Let me know when you outside, because we on our way to the. All right, here I come. Yeah, bro. That dude ain't had nothing to say. Hold on, let me throw on some shit, because I have to take some pictures today. Yeah, we on our way to the East Oakland Boxing Association, bro. It's time. You ain't got 10 on you, $10, $12. I got it for you if you ain't got it. So I could pay for your membership.
Oh, I got a card.
Oh, you got a debit card? You balling now?
Okay, I kind of got some money.
Yeah, no, the membership is only $12 a week. You see what I'm saying? That ain't shit. Or $45 a month. You know, and you're gonna be fighting for the gym. So we might can see if we can get some sponsorship or something. But I'm live right now, my nigga. Nigga, talk to the live, nigga.
It was good.
Nigga, get in the chair, nigga.
I don't know what to say.
Nigga, they gotta see the nigga. Nigga, it's gone. Nigga, they ain't had nothing to say with that appeal shit, though. Like, there was nothing he could say. He don't even know why I'm appealing. That's the thing. Like, these niggas just handle evictions, bro. They don't know nothing else. So if you don't have nothing to say according to the appeal, then I should get my jury trial. So I don't know what they're gonna say, because she said the courts is making a decision. But they claiming they're gonna come in here on the 15th and do something.
Oh yeah, I got your paddles still.
Yeah, no, you can bring them with you. I got all my equipment. Yeah, bring them paddles, because we gotta drive to the east. Hey, listen, bro, you're gonna have to get your book like before June 1st. And I don't think because I'm gonna have to have you spar in the event. And I'm gonna be using probably little Aaron too. So you're gonna be getting some work with little Aaron's son. And then but we ain't gonna be doing regular sparring, bro. We ain't gonna be just going out there doing stupid shit. We're gonna be doing some jab sparring and just giving people a look at what they can learn and shit like that.
How old is his son?
He around Aaron's son a little bit younger than you, though, I think. He around like 8, 7. He might be in high school or some shit. Let me go some draws real quick.
I didn't even know that nigga had a son until you said
Aaron
something.
got 2 sons.
I didn't know that till you like told me the first time.
That nigga had a kid early. That nigga Aaron been off the point, bro. No, you gotta just try to get this work in, bro. You can't be playing. Like, it's time now. Ain't no fucking playing. It's time to work.
Yeah, most definitely.
Working. And you get the gym. I just need to make sure I got some training so we be kind of warm in that joint. Dude didn't even have nothing to say. Nigga on my channel talking about, you got your back busted. No, I actually did. He has to, they didn't even know, that niggas don't even know what I'm in court for. When they talking about a pack busting.
Yeah, like, what is that nigga talking about?
Rebuttal that work I got. Niggas don't want to rebuttal that shit. He don't know how to rebuttal it. So he would rather say, I don't know what he's talking about. Yeah, that's all he can say, bro. I don't know what cuz got going. I don't know. Yeah, we know you don't, my G. Yeah, so we gotta go get this work over here. And this is the boss lady. She the head boss lady, but I'm the next guy. So we're definitely about to go over here and put in this work in front of her, nigga. And you already, you see what I'm saying? Why you gotta be sharp, my nigga?
Yeah.
Like, now we in position. If you wouldn't have been sharp, it would have been like, well, damn, why would we? You know what I mean? Like, why is he getting some work? He's not even ready. And at this stage, you know, you already know boxing to a certain aspect.
Right.
We good. We just gotta get this work in. Definitely gotta get this work in. Yeah, we about to get this work. We about to hit this gym up. I tried to tell y'all that I don't be talking about shit in court. They'll let everybody else argue their points. Soon as I get in there and they get to try to, well, no, sir, we doing it. Yeah, well, Troy King is here. What you want to hear from me? That's what I had to tell her. Like, listen, bro, they was on a thing. Dude was trying to be funny. Like, nigga, you Troy, they busting your pack. No, they actually not. The whole point of going into court was to see if dude had any rebuttals to my proposed settlement statement. He had no rebuttals. His pack was busted. Like that, and that's the thing I kept telling niggas. Nobody ever wants to rebuttal anything I say because it's gonna be a bag. And you can't do shit. Hey, listen, we gone. Y'all heard? I told y'all. I told you. I told you. Y'all think it's a joke. Let me hold on. Hold on 1 second. Bang.
We're bringing both of these too? Or just
I'm bringing all of them. Actually, do me a favor. Where my keys at? Hold on. Oh, they right here. I put that shit in the car real quick for me. No, you know I'll put it in there. Just gather it up. So I'm going to change my clothes so we can get ready to go.
So what time should I come through earlier now? Since or the same time like today?
Same time today, for real. Don't lock my keys in there. Don't lock my keys in there. Okay. Just throw it in the back. I'm on my way.
And the gate key again is this one, right?
No, the gate key, I'll show you. The gate key is the gate key is this key. The square. All these keys, this little conglomeration, key to the crib, I'll change my locks, and that's the gate key. Real quick, this is what I be trying to tell y'all. Y'all got to understand. This is Troy DeMond King, or Troy DeMond of the King family. This is the trustee Baylor. This is not you, bud. Nigga. Now you see right here it says the similarity in names of the undersigned and the vessel and commerce, two distinct and separate legal entities, is testament to the undeniable propinquity that Troy DeMond King. Hold on, y'all tell me. I want you to tell me real quick. You see that? You see the uppercase? You see that? Troy DeMond King Trust, originally an incorporeal creation of the government/parents, is dependent upon and only exists because Troy DeMond of the King family, or Hamza, the natural man, exists in living, breathing flesh and blood. You see that all right there. You could read that. That's called trust fund paperwork. Highly advantageous since birth. They're telling you what's going on. The undersigned having full control of trust revokes all permission to the government and any political subdivision or organizations to use copyright trust named Troy DeMond King Trust or trust in any fashion except by risk. See, this is why I keep telling them. Y'all keep trying to tell me my name is Troy King on that paperwork, and that's not it. You put what name you wanted to put on there. That's not my name. I kept saying that. No, Troy is not. This is not commercial. No, this is commercial. You telling me something's commercial how are you telling me it's not commercial? You can't tell me it's not commercial. This is a commercial entity. You see it right here. Attention to all governments. It's a legal notice and demand to all federal, international, public officials. Right here. You see, these are not my laws. See, when you get to trying to tell them, no, under these laws, as soon as I start, no, 28 U.S. code, she's trying to just cut me off in court. She don't even want me to get that off. She doesn't want me to get that off in court. My G. That's what I keep trying to tell y'all. But niggas want to run their mouths. They're not going to let you get it off. Because it's going to fuck their world up. They hate it. Damn, this nigga no. That's why she was in there smiling like, yeah, we doing this on Admiralty Maritime Law. What is we doing? Because y'all saying, like, I don't know what y'all doing at this point now. Like, what are you attempting to try this under? This proposed settlement statement? What are you doing? Or you already made your statement. All right, well, is he going to rebuttal the statement? No, I don't know what's going on. Oh, okay, now you don't know what's going on, my nigga. All right. I get it. If you don't know what's going on, I don't either. I know one thing, ain't no throwing no shit out. So we definitely gonna see what they got to say about that. And it's already been filed in United States District Court as a secure party creditor. That's what I tell y'all that, but y'all don't want to hear that. Y'all wanna be joking and yeah, you got your pack. No, y'all seen a pack busting. Ain't no rebuttals. They don't have no rebuttals. They don't know what the rebuttal. Because they're not trying to lose and look crazy. I keep saying it, but niggas don't want to hear that. Niggas don't want to hear that. They cannot rebuttal any of my paperwork that's filed because it has different jurisdictions. I have unlimited jurisdiction. That's why every time that's not irrelevant at this time. Okay, it ain't got to be relevant. It's all right. But in the appeal, it say I want to talk about the trust documentation, the American States Assembly. She's saying that's not relevant. Why ain't it? It's in the appeal. It's written down on the appeal. And that's why. I'm like, what's on the appeal? I've written it down and filed it. So why are you saying this is not what we're supposed to be talking about? That's how you know that's cap. But listen, we about to get out of here. We got to go train. Thank y'all for paying attention and looking. But I keep trying to tell y'all, man, y'all gotta understand some laws and stop running your mouth. You see that? Uniform Commercial Codes, the Fair Debt Collection Practices Act, and this contract. These charges shall be assessed against persons, government bodies, and corporate entities. Listen, y'all can say what y'all want to say. But this shit, I didn't write this. I just, look, you see my name right there? I had somebody do this for me. So you're talking. You're just talking. You're just talking. Anybody in here. If you don't have the facts, you just talking. If you don't have the facts, you just talking. Quiz, the nigga didn't have nothing to say about my appeal. He made no arguments on the appeal. He made no arguments on the appeal. Y'all don't even know we was in court over a proposed settlement statement that I made to settle the case. And he had no anything to say. I'm going to be back later to talk about it. I got to go to work at the gym. We out. 1.